everybody has preliminary charge packet.
Yes.
Or Danielle either emailed or gave you.
Yes, sir.
Okay.
And Judge, we wanted to see if the court, if we're going straight into the charge conference, if we could possibly address the defense's lesser included first, just because our office will have to, it's gonna be a long verdict form, and then obviously, argument wise, we wanna know what we're arguing.
Okay.
And then we'll kind of circle back to the charge conference anyway, certain things do or don't need to be included.
All right. Reasonable.
You want to do the lessons first.
And I printed out, if y'all are okay with me giving it to Brian, just your email of what it was, and so you laid it out by count.
Yeah, that's fine.
Copy for the judge and
No
for
objection.
Danielle.
You authenticated?
Sure hope it was you that sent that to me.
Judge, should we do the directed verdict first?
If you want to, we do that first, it's fine. Yeah.
Not gonna take long.
Okay.
I thought we'd go ahead and get that out of the way.
Excellent.
Judge, defense is asking, case be dismissed at this point. We're going to adopt the motion that we had initially, on, that the court heard, back several months ago.
The demur, is that what you're referencing?
Special demur.
Okay.
We want to adopt that and add to it, Judge, that in looking at a number of cases, and these are relatively new cases, and of course aware of the Melicon versus the state at 319 Georgia 741. We talk about cause and fact and legal cause, which means proximate cause, and then looking at that foreseeability or likelihood of death happening in a way that it did. Foreseeability on the defendant's conduct. We don't know at this point what conduct is criminal, because it's not against the law to have a weapon or ammunition not locked up. So when they're talking about criminal conduct, then you have to go farther than just the criminal conduct and what that reasonable foreseeability is. We don't believe that the state has shown that. Further, Judge, in looking at Code Section 1611-101.1, I think the state uses the language from that particular code section when they're describing the what they intend to prove on the large number of counts at the very end of the case, which is the cruelty to children. So we believe that the state does not carry the burden to show sufficient warning, nor have they shown under the two-pronged legal cause and cause in fact, the proximate cause, the foreseeability that Colin Gray would plan this out to this extent, the foreseeability of him being able to take a long rifle into a school goes beyond what I think the state has intended to show in this case. For those reasons, Your Honor, we would ask the court to dismiss at this point. Thank you.
Thank you, sir. Who's responding?
I'll respond.
So the court denied the charged proximate cause within the indictment. So now what we have to show is that we have provided enough evidence for the case to get to a jury for proximate cause, which is essentially their argument that we haven't. In Johnson versus State, which was an involuntary manslaughter charge and cruelty to children in the second, that was before the new statute for murder in the second degree came about. In that case, a mother left a 3-year-old, a 4-year-old, and a 2-year-old completely unattended for an extended period of time in a room that had a space heater. And in that case, the evidence was sufficient to find that she committed involuntary manslaughter and the commission of reckless conduct. Obviously, owning a space heater is in itself illegal, but the manner in which she owned it was illegal, and that is what the state's contention is. Owning a firearm and owning ammunition is not in itself illegal. Owning it and allowing access to it in the manner that the defendant did rises to the level of reckless conduct, it rises to the level of criminal negligence, and therefore it rises to the level of a criminal act. For proximate cause, for both criminal negligence under Putnam versus State, 257 Georgia Appellate Courts 902, and proximate cause under Butler versus State, 363 Georgia Appellate Court 753. These are questions for the jury to determine. The jury is to determine whether or not the state has proven criminal negligence and whether or not the state has proven proximate cause, as long as we have provided some evidence that the defendant was criminally negligent and that these deaths were the proximate cause of his criminal negligence. And the state certainly has provided a lot of evidence of warnings that the defendant received in the form of Colt's deteriorating mental health, in the form of the violence that he was showing at home and alluding to in his text messages, as well as the red flags that were clearly present that showed that Colt was obsessed with school shooters. So there's definitely sufficient warnings. Those warnings are what make the manner in which Colt harmed people reasonably foreseeable. I don't believe the standard is that the state has to prove that the death in the exact manner in which Colt committed this crime is reasonably foreseeable, that he took a gun on a bus to the school. But it is reasonably foreseeable that Colt would kill people with his gun and harm people with his gun, and that's certainly when you provide a 14-year-old with mental health issues, with violent tendencies, and a clear interest in school shooters, it is reasonably foreseeable that he will use that gun to shoot people. And the state has provided enough evidence for that to go to a jury.
All right, I do think that proximate cause is almost always a question of fact for the jury to determine. I do think that there is evidence upon which the jury could in fact find proximate cause here, so I will deny the directed verdict.
And Your Honor, before we move on to charge conference, may I be excused to go continue to prepare for closings?
Yes.
Thank
Yes.
All right. So coming back to the lessers. All right. So I've lost the email now.
Jeff, oh, sorry.
I was just saying, so the defense wants,
We can start with the ones we don't object to.
Okay.
I don't know that that'll simplify it much, but on counts 5 and 7, involuntary manslaughter is indicted as an unlawful act. They are asking for involuntary manslaughter as a lawful act, and of course, in an unlawful manner. I think under current case law, that is appropriate. So we would not object to that as a lesser included on those 2 counts.
requesting 3 lessers for murder of the second degree, involuntary manslaughter, lawful act, involuntary manslaughter, unlawful act, and contributing to the delinquency of a minor.
Yes. We do object to those, starting with involuntary manslaughter as a lawful act. I think essentially to get that as a lesser included, the state would have had to, there has to be some evidence that merits the lesser included, being that either the victims in those counts, count 1 and 3, were over 18, or that there wasn't quote excessive pain. I don't know that any evidence has been put forth showing that. I do have a case, it's Castro Moran versus State, and that's 356 Georgia Appeals 248. That's a 2020 case.
Did you say 248 or 348?
248.
Okay.
And essentially that case says, a trial court is justified in refusing to charge on a lesser offense where there's no evidence that the defendant committed a lesser offense. I think there was a question of, for example, the victim's age, that could be appropriate, but I don't know under this situation that it is appropriate.
Mr. Hobbs? Is it Hobbs or Mr. Barrett?
Mr. Barry. We're under for involuntary. Okay. Mr. Hobbs.
Miscue.
Judge, so on the involuntary manslaughter, state must prove the defendant caused the death of another person without intending to by committing the offense of reckless conduct, which is charged on other defendants, though in counts 1 and 2, obviously it's charged as a cruelty in the second. We believe, and this will kind of dovetail into the involuntary manslaughter lawful act, because the only difference between the two is an allegation of reckless conduct versus committing a lawful act in an unlawful manner, which was likely to cause death or serious bodily injury. We feel it is appropriate due to the fact that he is charged in such a way that he's absent all malice, so without intending to, which is the second element of involuntary manslaughter, causing the death of another person by committing the offense of reckless conduct. So reckless conduct is defined as endangering bodily safety by consciously disregarding substantial and unjustifiable risk that the defendant's act, in this case, leaving access to a firearm and ammunition under circumstances the state intends to prove in terms of consciously disregarding that risk would endanger the safety of another person. Obviously, the conscious disregard must rise to the level of a gross deviation. We think the jury could find that he committed involuntary manslaughter based on the elements of that as applied to counts, what was it, 1 and 3 for the minors involved. Yes, sir. Same thing for the involuntary on a lawful act. If they determine, they being the jury, that the way in which he stored the weapon and ammunition did not rise to the level of reckless conduct, then they could find that he committed a lawful act in how he stored the weapons, because it's not against the law in Georgia to store weapons in any particular way or any requirement that the weapons be locked up. And the jury then determined that the way he stored them, although lawful, still was likely to cause death or serious bodily injury. They could find the involuntary manslaughter lawful act in a non-lawful manner, so we would ask the court to include both of those as lessers to counts 1 and 3.
Or, do I understand Ms. Daniels' argument that you're saying because of the additional elements of the age of the victims that these lessers don't apply? Is that?
I am not saying that involuntary, so I was only talking specifically about unlawful act. I'm not saying that there's not a world where involuntary manslaughter, unlawful act could be a lesser included, but I think the evidence that that lesser included should be given under this Castro-Moran's case is, there's no evidence that, it's kind of hard to prove a negative. Like I said, we're talking about the elements of age and causing cruel and excessive pain. There's nothing to show that those elements are in question. There's been no evidence presented that those elements are in question. And when the differing elements between the lesser included and the indicted charge, if that's not present, there's no reason, the trial court's not compelled to give that lesser included.
Do you have any case that goes through sort of a factual analysis? I mean, I realize that the general rule, there has to be some evidence to give a charge, but do you have a case that we can use as an analogy, or?
Not for these specific charges. Let me make sure that I have the right case here. The Castro Moran case, essentially, so it's not exactly the same, of course, but that was essentially failure to seek medical care situation, cruelty to children in the second, resulting in murder in the second. And so in that case, so it is, I think it tracks the logic, the case that I provided.
Mr. House, was there a specific case that you all felt was helpful?
No, Judge, we would just point to the language that the court has already articulated, and that if there's any evidence, the court should give the lesser included defense. And we think there is in this case.
All right. Reserve on that one, and I'll look at some cases on the recess here. Are you also requesting, according to the email, contributing to delinquency of a minor for the murder in the second?
Yes, sir, we are.
Any argument, or did you want to?
Sure, I can go first. So that's obviously a very extensive statute with many different provisions to it, and then refers back to a different statute in terms of the definitions. However, what that statute says based on 1612.1 subsection B, subsection 3, is that a person commits the offense of contributing to the delinquency of a minor, the minor in this case being Colin Gray, when such person willfully commits an act, or more importantly, as it says in the statute, willfully fails to act, when such an omission would cause a minor, Colin Gray, to be adjudicated to be a dependent child, as such term is defined in Code Section 1511-2. 1511-2, dependent child is defined as a child who has been neglected, as in need of protection by the court. Neglect is defined in 1511-2, subsection 48, subsection A, as the failure to provide proper parental care or control, subsistence, education, or required by law, or other care or control necessary for a child's physical, mental, or emotional health or morals. A child, as it says in the same statute, is considered in need of the protection of the court if that child commits what's known as designated felony, either A or B. The charges against Colin Gray in his indictment qualify as a designated felony under A, and because the way this case is indicted charges Colin Gray, irrespective of intent, with failing to lock up his gun, failing to supervise Cole, failing to provide him with mental health care, that fits the statute. It's clear that he has been charged with what would be the equivalent of designated felonies, and as such under that statute would be defined as a dependent child who's been neglected by Colin Gray's failure to do certain things. This statute fits, and as the court stated, there is evidence, it's only slight evidence necessary in order to give the charge, and in this case, frankly, Judge, this charge fits better with what the evidence that was presented in this case and the arguments that were made in this case than any other statute. So we would ask the court to charge with contributing to the delinquency of a minor.
And Judge, I'll address that, and then I do need to circle back to address involuntary manslaughter lawful act in relation to the cruelty of the murder second charges. But regarding the contributing to the delinquency of a minor, I do have one case. It's Staib, S-T-A-I-B versus State. That's 309 Georgia Appeals 785. That's a 2011 case, and I believe the statutes that is looking at were slightly different at the time. So it's looking at cruelty in the second and then contributing to the deprivation of a minor, but the logic is still the same. That case says that they do not merge as a matter of law. And I think, like I said, even though the statute language might be slightly different, the policy behind the statutes and the wording of them track along with what our statutes are now. The other thing, Judge, and the main issue that we would take with the contributing to delinquency of a minor, well, we wouldn't disagree with Mr. Hobbs that it could very easily be argued that the defendant contributed to the delinquency of Colin Gray. Adding this as a lesser included is putting a lesser included with an entirely different victim. The named victims in these counts are Christian and Mason, and as well as all the mentally and physically injured victims in the indictments. To include a lesser included where the state has to prove a different victim, which in contributing to delinquency of minor, that would necessarily, under that statute, have to be Colin Gray. That doesn't logically track with how a lesser included works. I can't think of any scenario where you could put in a lesser included that would require the state to prove an entirely separate victim just because that victim is part of the language of the charging statute in the indicted charge.
Last words.
Sure, Judge. We would just rest on the argument as previously given in that if there is any evidence, the court should charge it, and we believe there is sufficient evidence in this case to warrant charging contributing to the delinquency of a minor based on the evidence that's been presented thus far.
And Judge, can I go back to the lawful act, unlawful manner for murder in the second?
Okay.
So our argument here is different than that for felony involuntary manslaughter, in that, like I said earlier, we conceded that under current case law, involuntary manslaughter lawful act would be an appropriate lesser included for counts 5 and 7. Because the wording is different for involuntary manslaughter and murder in the second, it doesn't line up to be a lesser included because the mens rea for those two counts, for those two charges, is the same. In involuntary manslaughter lawful act, the pattern charges, so that's criminal pattern charge 2.10.44, specifically says under the bench notes, you must include in your instruction the definition of criminal negligence, which is the same mens rea for the predicate cruelty to children in the second to get to murder in the second. Inherently, if a jury were to find that the state proved criminal negligence as they would be instructed under the pattern by the court, then they have found that predicate mens rea to find cruelty in the second and thereby logically find murder in the second. It's a different language, a different mens rea than is laid out in felony involuntary manslaughter. I don't have the case citation in front of me, but that would be contrasted with State versus MacGyver, which very wordily and lengthily lays out the logic of why lawful act would be a lesser included of unlawful act involving manslaughter. But because the mens rea specifically in murder in the second is criminal negligence, and because the mens rea for a lawful act in an unlawful manner is specifically criminal negligence, to instruct the jury that they could find it to be a lawful act when if you reach that predicate mens rea, you've inherently committed cruelty to children in the second, would be cognitively dissonant and not an accurate statement of the law.
Anything else on that?
Sure, Judge. So the way this case has been changed is you unique to the jurisprudence in this state in regards to Colin Gray is charged with cruelty the second in not to anyone he ever came in contact with. We've got a couple of different layers in terms of how he's charged with cruelty the second, in terms of he's charged with cruelty the second based on what someone else, an intervening act, did to these other folks. So what we think is that the way the statute is with lawful, you could still find criminal negligence, yet not find the proximate cause in cause and fact and legal cause necessary to go that further step to the cruelty in the second. Therefore, we think that the evidence that's presented could be criminal negligence under both situations, murder in the second, and also involuntary based on a lawful act, because there is no law that he lock up his guns, and find in both cases that he was negligent, yet not find the proximate cause necessary for the murder in the second, and then they would be authorized to find involuntary based on a lawful act. So based on there being slight evidence or some evidence that would satisfy that, we would ask the court to charge involuntary based on a lawful act.
And Judge, may I just briefly respond to that?
Go ahead.
Our position would be if the jury were to find that Colin Gray committed criminal negligence, and then there's no proximate cause, and then something horrible happens over here, and the jury does not find that there's a proximate causation between the two, that's just not a crime. So that would be the jury's prerogative as the finder of fact.
You're saying it still wouldn't be involuntary?
It still wouldn't be involuntary manslaughter, it'd be two things that without proximate cause are not legally related.
All right.
And I'm sure they'll argue that extensively.
All right, it's the argument, so we have cruelty to children, various counts through the indictment. You're arguing or asking for contributing to delinquency. Any additional argument?
No, sir, it would be the same one I've already articulated.
Any additional?
Same.
Then we have, let's see, count 6, 8, 27 through 29, reckless conduct. And it says not asking for a lesser included.
We're not asking for a lesser on that, Judge.
Okay.
And they are still asking for furnishing the firearm.
Consulting my boss.
So you're at, but you are asking for furnishing a firearm to a minor?
We'll be asked for the furnishing. We'll be asked for the furnishing pistol to the minor. Yes, Judge, we're gonna ask for, it's on my phone. Furnishing a pistol, it's actually furnishing a pistol or revolver to a minor. So I will go ahead and admit to the fact that that statute does not perfectly track what we have in this case, and obviously the allegation is not that he used a pistol or a firearm. However, the language in 1611-101.1 does use the same language as the cruelty counts as presented in the indictment, the spirit of that law in that providing a firearm to a minor who then does something illegal with it would fit the facts that we have in this case, therefore being slight evidence that it is enough to get the charge to go to the jury, so we would ask the court to charge that.
Stand.
And Judge, that just, I think that charge just wouldn't follow the evidence in this case at all. So that statute says, for the purposes of this code section, pistol or revolver means a handgun as defined in code section 1611-125.1. Again, the court's not required to give a charge if there's no evidence for that. There's been no evidence in this case that Colin Gray furnished a handgun to Colin Gray.
They concede that. They're basically saying, we want to transfer it to a long gun, a firearm.
Well, that's just not what the law says. I can make my own personal policy statements about whether or not I think that should be illegal, but that's just not what the law says. And the law does not say that it's illegal to furnish this kind of firearm
So
to a child generally.
y'all agree it's illegal to give them a handgun, but not illegal to give them a hunting rifle?
I believe the way that intent of that statute is to prevent an adult from furnishing a weapon, a firearm, to a minor. That's what our argument is. There really should be no difference between an AR-style rifle versus a handgun or a pistol. We think the intent of the legislature in passing that is to prevent the same exact act. Therefore, we would ask the court to charge it.
And Judge, they wrote in specific parameters for that, and then under 1611, 125.1, handgun is additionally defined. It's, I don't know if the law was written to the exact intent to contemplate every scenario, but the law is very, very clear.
All right. I'll have to look at some case law on the lessers there, so let's go through the charge packet. Does
Okay. Ready, Judge?
does everyone's packet have 13 pages? I just want to make sure we're all looking at the same thing.
Yes, sir.
Yes, sir.
Okay. So I know Ms. Daniel's familiar with this, but Mr. Hobbs, what we'll do is I'll just go page by page. This is a preliminary charge packet. For instance, if there's no issue on page 1, I'll actually put a check on page 1. This will be a court's exhibit so that they can compare what we said we were, what changes we were making based on this preliminary packet.
Yes, sir.
Okay. So page 1, the only thing that wouldn't be straight from the pattern is the state just asked, I guess, that basically I summarize the counts instead of listing every count, but I am going to read the indictment.
Okay. That takes care of that.
So you're not going to do the thing that we did earlier? I mean, it doesn't matter to me.
Yeah, I think because with Sumter, it does take a long time.
Settle in.
Do both sides want me to just do the summary, as I did in
I don't have an opinion, Your Honor.
jury selection? And when we say summarize, I mean like in jury selection where it was
Yes.
basically putting multiple victims' names for each count.
Judge, we don't really have a position on that. We'll leave it to the court.
All right.
I think we did. I'll talk. Get that from maybe Adams.
Well, I'll decide. I don't.
I just need to know how many minutes
Yes,
to
sir.
bring, Your Honor.
How many what?
How many minutes to bring.
I think the state may have left out a couple of people that they didn't bring in on the indictment, Moon and maybe Adams.
Correct. We did not, Tyler Moon and Lady Adams did not testify.
So I think we would have to, there was no evidence presented on those counts, so I think we would have to strike those counts.
That's not correct, Your Honor. We had a seating chart. We had a chart with Ms. Ryan where she said these children were present in the room. Had a separate seating chart that showed them present in the room. People testified they were present in the room, and then there was the video that showed them present and showed the children present in the room.
Which charges, which counts are they?
Those, I have the indictment, Judge. Give me 1 second.
They are both, of course, only charged regarding mental pain. Neither are regarding.
So it's count 21 is Tyler Moon and count 9 is Landon Adams.
Is Lane, so they're both mental pain? Is that right, Ms. Daniels?
Yes, sir.
Is a jury permitted to wholly infer mental pain without any evidence?
Your Honor, there was evidence from multiple witnesses about how the room was behaving, everyone's fear in the room, and then there was also the video that showed the manifestations of the children in the room. So they could use that evidence to make that decision.
Judge, of course, we think those counts should be stricken because there was nothing specifically testified to about that. I can't testify about what your mental pain is. So, the fact that they were all scrambling around on the floor and that sort of thing, I don't think that's something that you can transfer from
you're asking for a directed verdict.
That, on those counts, Judge.
All right, 21-9. All right, we'll, does anybody have a case they want me to read on that?
No, you're right, just practicality. We routinely have counselors talk about how children behave and act, and in this case, you have a video of how they're behaving and acting. The jury can use to infer that.
All right. I will reserve ruling there and come back to it. All right. Any other issues with page 1?
Nothing to say, Your Honor.
Mr. Hobbs?
No, Your Honor, and just for the record, that would be, those are all pattern charges, indictment, issue pleaded not guilty, presumption of innocence.
Yes.
No objection.
All right, page 2. These are also all pattern. Danielle, is this my modified direct and circumstantial?
Yes, but all the one, I just think about the premises itself.
Understand?
Yeah.
So, the direct and circumstantial, this is the pattern. There's a parenthetical, and I think it's just confusing extra language. Do you remember what it is, Ms. Daniel?
The confusing extra language?
That I take out.
That's not off the top of my head,
All
but
right.
I know that the state does not object to it.
I can pull it up.
All right. She'll pull it up and read it. The defense is asking for grave suspicion. I do give that charge.
And Judge, for the record, the state would object to grave suspicion just based on a litany of case law that says it's not error to not give it.
All right, overruled and given it.
It's, okay. Well, like the paragraph at the top.
I don't think you're right. Someone's right in circumstantial.
Oh, I think.
All right, we'll come back to that. Looking at page 3, here's the standard credibility of witnesses. Do y'all want their intelligence or not?
No, sir.
Ms. Daniel, do you,
We don't have any position on that.
All right.
I'm taking it out.
I'll just take it out. So coming back to, page 2, direct and circumstantial, I generally give the short version, which is what this should be. It's in the, so it says circumstantial evidence is is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. I put a period there. I think most jurors know what an inference is, rather than saying, that is, by consistency with such fact or elimination of other facts. I
I don't even know what that means, but
Well, that's why I take it out.
Yes.
So I put a
I'm
period.
fine with you taking that out, Judge. No
All right.
objection. There obviously has been movement to get rid of stuff like that as they're doing these patterns, so.
I think they've already redone that one, so they didn't.
Yes, I think so too.
That one they left. No disrespect to Chuck and Bernie.
Right.
All right. right, so we've got expert witnesses, back on page 3.
Just for the record, Judge,
Yes,
so I guess that means we're done with page 2. So no objections to, on our part, to any of the 4 charges on page 2.
all right. All right, this should be pattern charge on expert witnesses. I'm assuming no issue there.
No, sir.
All right, so then we've got, I think this was a state request, witness attacked. The only one that I guess could be applicable is the bias.
I would argue the character of truthfulness shown by specificness as the conduct of the witness in question brought out by cross-examination.
But I think it's specifically related to the witness's character for untruthfulness.
Okay.
Yeah, I think it's the particular, like, truthful, untruthful, whether it's a reputation or some specific instance. I think you'll get what you want probably on the, with any other charges. Do you all want the bias?
Yes, sir, we do.
Ms. Daniel?
We wouldn't object to it.
All right.
And then I don't believe any felony convictions have been tendered for impeachment purposes.
All right, so from that one, I'll give the bias. All right, witness impeached, I generally give the, what's after the or. State has picked up on by this point and made that request.
No objection.
All right, so for witness impeached, it'll be only the after the or. We have, we'll just go ahead and count prior statements on that's page 3, since it starts there. That's from the pattern. No issues there, I presume.
No objection.
All right, so page 3 is good. Is that right?
Yes, sir.
Page 4, we've got single witness. Any objection from the defense?
No objection, and just going forward, we'll withdraw our request on defendant's choice not to testify, obviously.
All right, now, you want it withdrawn in its entirety, or do you want me to, the defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness? You should evaluate such testimony as you would that of any other witness. I generally give that, I think I've always given that when the defendant testifies.
I would object to it, Judge.
You see, you do object?
I would not.
Okay.
Sorry, Judge.
That would be appropriate.
All right, so I'll just give this top part of that where it starts, however, I will not give that charge.
Do you want to change the title then? Defendant's choice to testify?
Sure.
Right.
So this 132.15 statement of defendant, that's not an actual charge to give the jury, it's, I'll call it a bench note.
Yes, sir.
So that's not something I would read to the jury.
We can withdraw that, Judge. Make it easy.
So then we have, does your packet have limiting instructions? Does your packet have 134.00?
It has.
Okay, so we took out 134.00. There's no
Okay.
classic limiting instruction like other act evidence. But I do think I need to give 134.50 here, really conditional admissibility. They heard his statement or statements. They do have to make findings of voluntariness to be able to consider that statement.
Yes, sir.
All right, so I would give 134.50. Is there anything else on the bottom of y'all's page 4?
Statement of defendant, 132.16.
There's parentheses, 3134.15, not the top one, but in the bottom.
All right, Danielle pointing out a parenthetical in 134.50. In the middle, it is only admitted and you may only consider it if you find certain required, in the parenthetical, but disputed predicate facts. voluntariness, and I know we had a motion on it.
We did.
Do you want the parenthetical read?
Yes, sir.
Okay. So we will. Stan, I'm assuming y'all are fine, but if you're not, let me know.
Yes, sir. we're fine with that.
So page 4 then, we've got statement of defendant. All right, we good with page 4?
Yes, sir.
Yes, sir. No objection. I should say no objection to 132.16.
So I need to give 132.17 defining voluntariness. I don't think I would be given the parenthetical at the bottom of that charge.
We agree with that.
No objection.
And we would, I believe, withdraw 132.18 out, that applies here based on previous rulings by the court.
What's your position, Mr. Hobbs?
I think we would ask for it, Judge.
So the rub, and if you go back actually to that 132.15 on the previous page, that was really a bench note. Down at the bottom of that, if the court determines the defendant is or was not in custody, the court should give the voluntariness charges only. So with Jackson, I did find that he was not in custody when he gave the statements.
Yes, sir, you did.
And again, jury has to determine voluntariness, but, 132.18 does seem to be more appropriate if he was in custody at the time. What's your position there, Mr. Hobbs?
Well, I would agree you did find he was not in detention at the time, so we'll leave it to the court.
All right. So I'm going to take out 132.18, just, it's not being applicable. I would, of course, give 132.19. So that the constitutional rights, again, would not be applicable based on the ruling from Jackson Ditto.
Yes, sir.
So I'll take that out. Was y'all's page 5 in there?
No, sir. We have burden of proof as to rights, and conditions, precedents, considerations.
Right.
Um,
So burden of proof would come out
Yes, sir.
because of the constitutional rights coming out, so.
All right, so page 5, good?
132.50 on that page.
I have a slightly different packet.
It's only 3 lines of that one on our page 5, the rest of it's on page 6.
All right, so let's count that as page 6. Page 5, good?
Yes, sir.
Yes, sir.
Yes, sir.
All right, page 6. So the state provided a version that retains the requirement that the statement be voluntary, but removes the issues with Miranda and those constitutional rights. Mr. Hobbs, do you have any issue with what's listed as the state's version of 132.50?
I would just object to any of it coming in. 132.5 doesn't fit based on you taking out 132.1 and 132.40, which I agree should take those
statement, before you consider it as evidence, you must find it's voluntary, and it talks about all the things if it's not voluntary. But it never says, if you find it's voluntary, then it's evidence. So I think it's necessary to kind of close that loop.
Yeah,
I would just say that it does say to be voluntary, and it defines what voluntary is. The statement must be the product of a free will and not under any compulsion or necessity imposed by others, which I think is for every, covers that exact same, just doesn't highlight it.
But what I'm saying, if you go back to page 4, 132.16, that's where it first starts talking about it. And the first statement is, a statement that the defendant allegedly made an offer of consideration. Before you may consider this as evidence for any purpose, you must have determined that the defendant's statement was voluntary. And then there's lots of stuff about what voluntariness is and how if it's not voluntary, you can't consider it. But then you never go back and say, but if it is voluntary, then you consider it as evidence. And I think you need that charge to close that loop.
all right, over objection, I think it's appropriate. It's really just removing the parts of 132.50 that are inapplicable because we don't have to deal with the constitutional rights since he was not in custody. So I will give the state's version there. I was a little confused on 135.10.
We'll make it easy. We'll make it easy. We're withdrawing 135.10 and 135.11, Judge.
All right, thank you.
Of course.
So preserving your objection to the modification of 132.50 is page 6, otherwise.
Definition of crimes on the code.
We got one more on ours.
Definition of a crime. What are y'all's thoughts there? So, and just go ahead and address intent too. You know, I've never tried a case where every charge was a criminal negligence charge. So I've never not given 141.10 intent, but I think it creates a problem for us with this being criminal negligence, to give 141.10.
I would agree with the court in that I don't believe 140.10 fits the charges of this particular case. I would object to that.
Daniel, what's your position?
So you're just saying take out 140.10 entirely rather than adding on?
No, 141.
Well, I think Mr. Hobbs is saying both would fall, but if I understood him correctly. But,
You did, Judge. Covered both. I don't think they're appropriate for this case.
And I think criminal negligence instructions, things of that nature would basically fulfill the role of those instructions in this very specific case.
all right, so are both sides then in agreement that 140.10 and 141.10 should be removed?
Yes, sir, I think that would also be 141.11.
Yes, sir.
All right. So all three of those then, consent on both sides will be removed. States ask for 141.12.
trying, I don't know if it fits.
I've stopped using that by and large unless
Yeah.
there were some allegations of,
That's our issues. I don't think there have been any allegations that,
I think the natural and probable consequences of those acts kind of echoes a little bit our proximate cause.
right.
And that would be our contention, Judge. These are, in this specific case with these specific charges, this presumption, which is an accurate explanation of the law, is relevant and will help the jury in making their assessments. They're having to measure against what the legal concept of a reasonable person is, and this, I don't think, has any negative reason. There's nothing negative to keeping it in, and I think it could provide clarity to the jury.
So we would object. We'd ask that it be taken out.
You could relate that to Colt instead of Colin.
All right, I'm
It
gonna
would
just,
be confusing.
I'm gonna hold on to that one for a minute. So just consider that a reserve ruling. I don't know, did the state ask for 140-15 multiple ways? It could
Yes,
be
sir.
done? And that's based on your criminal negligence, second degree, cruel, mental and physical?
Correct.
Those are the only charges you're really referencing?
I believe so.
Mr. Hobbs?
Yes, Your Honor, objection.
All right, so I'll give that one. We have venue, y'all take a look at the state's version and see if you have a problem with that. And that, some of that is probably just based on my rulings in the past. I don't know why I'm telling a jury, in a prosecution, in any case in which it cannot be determined in what county the crime is committed, venue's proper can be proved in any county. That's just not an issue in this case.
I don't have an objection to the state's first objection.
All right. That is what I'll be giving. All right. Murder in the second degree. It's from the pattern, except the state requested irrespective of malice, which I looked at the statute. It's in the statute. It's also in the indictment, despite the little bench note or whatever there.
No objection.
All right, so I'll give 21035 with the added element of irrespective of malice. Cruelty to children in the second degree, 22822. I added, by consciously disregarding the substantial and unjustifiable risk that his act would harm and endanger the bodily safety of another, inasmuch as that is in the indictment.
And Judge, we don't feel that that's necessary to include there. I think the other statutory instructions are more narrowly tailored to the statute, and I think it'd be appropriate to keep cruelty, just that 1 through 4.
And we ask that you keep it in. It does track the indictment in the same way that 21035 does by adding that other number 2 subsection there for the state added element irrespective of malice. We think it's the same thing for the next charge. We ask that you keep it in.
Yeah, I don't know that it was necessary to be in the indictment originally. Kind of a lengthy footnote in the demurrer order, but I think its inclusion in the indictment kind of puts the burden on the state to prove it here. It's not just what I call throwaway language or elements. So over the state's objection, that will be included with the cruelty to children second degree charge. And we have criminal negligence.
And Judge, we provided that state's version. It does have a typo, and to be clear, I think it was our typo, not else, but for Daniel's sake. The last word there says nearby, it should be thereby. And looking at it against the pattern language, I think it would be clearer and just as appropriate to just add or failure to act to the end of the pattern.
Mr. Hobbs. Originally, I thought, yeah, that makes sense when you're talking about negligence. But when you look at the indictment, it specifies an act. It doesn't, it doesn't leave in there or a failure to act. It is the act of providing the gun.
And we think it would be appropriate just to charge the pattern.
I don't want to run into a situation where, an appellate court says, well, that's an alternative way of proving it that wasn't in the indictment.
That's fine.
So I'm going to stick to the pattern on that. And we have involuntary manslaughter, unlawful act, should be, I think it's straight from the pattern. Everybody fine there?
Yes, there's no objection to the pattern.
No objection.
Is that on page 8?
Reckless conduct.
So I would move reckless conduct. In your packet, Mary, you have moved, but to write under the involuntary manslaughter and unlawful act, to go ahead and define reckless conduct.
That's how we have it, and I think that would be the clear way to do it.
And that should be straight from the pattern. So any issue with the reckless conduct or page 8 in general?
No, sir.
No objection to the pattern.
Page 8 good?
Page 8 is good, subject to what we've already discussed.
All right, so then the defense has requested the involuntary manslaughter lawful act in an unlawful manner. And specifically as a lesser for counts 5 and 7, which the state consents to, then also counts 1 and 3, which I have not ruled on yet. So with the language of the charge, at least as for lessers in 5 and 7, does the state have an objection?
No objection to the language of the pattern.
All right. And then we have proximate call. What's that?
There's a bunch of things.
Where? No. So coming back, Danielle pointed out there parentheticals in the involuntary manslaughter lawful act. And the defendant acts or fails to act in a conscious disregard. For consistency's sake, would we just continue to say when a defendant acts?
I wouldn't, Your Honor, because I think we're stepping away from the indictment here. If you're talking about an awful act in an unlawful manner, it kind of leaves the unlawful manner up to them, and now the omissions and failure to acts come back into play.
What do you say, Mr. Hobbs? So lawfully, it's lawful that he had access to a gun, but he had it in an unlawful manner, or by failing to take the gun away. Just flesh that out for me just a little bit.
Well, I'm just saying, when you say lawful act, which they're saying having the gun and ammunition is lawful, in an unlawful manner, that's left undefined to the jury because it's not in an indictment. So unlawful manner could be omissions and failure acts. It opens that door for those possibilities also. The reason we took them out of the other was because it was limited by the actual charging document. But unlawful manner isn't in the charging document.
Mr. Hobbs?
Well, I think the act is leaving the weapons and the ammunition accessible, which in Georgia is unlawful.
All right, I'll reserve on that one and take a harder look at it. All right, proximate cause. So, you know, if you read it as is, the state must prove that the criminal conduct was the proximate cause of the injury or death. So, and really, it's applicable to, I guess, every count of the indictment. Is that fair?
Yes, sir.
Yes, sir.
So where y'all have submitted your own request, and each side did, are y'all wanting me to forego the pattern, or?
Judge, we provided, but I think it looks like the way you've got it is the first part of our request immediately under that, which tracks very closely. We don't think that the criminal conduct accelerated the injury or death in a significant way applies here. And I believe our version lays that out. So I don't know that the state's request specifically drastically modifies the pattern. We just have the additional language, which I'll discuss with you if you want me to.
This way.
What is y'all's position, Mr. Hobbs?
Judge, we submitted a non-pattern request on proximate cause that shows up on our page 10. We'd be asking for that. Starts the overall causation
Yes.
required.
Okay.
That one.
The state had another one too, yeah.
Yes, sir. On ours, it's at the bottom of page 10. You'll get a kind of flesh out our thought there.
Yes, and both of y'all are citing Mellon.
So Judge, ours, once you get past the language that tracks the pattern, we go on into talking about that proving its requirements is fact intensive, demands mixed considerations of logic, common sense, justice, policy, precedent, which are questions of causation for the jury. That language is pulled directly from Rosenbaum versus State, which is 383 Georgia Appeals 417, which is a 2024 case. Rosenbaum in that language cites Mellencon, which is 319 Georgia 741, which is also a 2024 case. We felt like that language would be particularly instructive to the jury in this specific case. Those two cases that we're pulling from, and again, we pulled the language directly from Rosenbaum. So Rosenbaum is a murder in the second predicated on a cruelty in the second, of course. So I think the policy behind that tracks cleanly with this case here. That was a case where the defendant allowed his significant other to be alone with children who he knew the significant other was abusive towards, resulting in the death of the child. So I think sort of the mens rea there of knowing what can happen is very analogous to here. citing Melancon, it's also citing kind of a novel legal issue. And again, these are both very new cases, both from 2024. Melancon was a felony murder case predicated on a possession with intent to distribute drugs. And so, again, in these cases, I think all three of these cases fall in this sort of intangible proximate cause consideration of the jury. So articulating for the jury what it is that they're considering, I think could be particularly helpful. It's not harmful in that it tracks the exact language used by the appellate courts.
I don't remember Rosenbaum offhand. I think you may have those reversed. Melancon was the abusive, leaving the child with someone who's been abusive in the past.
That's correct. Rosenbaum's the Clayton County case with the husband and wife. The wife was in law school and she was trying to, the defense was that she was performing CPR and the child in injuries came from the CPR.
I do have a copy of Rosenbaum. There's been a petition for writ on that case. I've got that before we like that.
And Judge, I was combining two cases, so that is accurate, and I do believe I stated correctly that Rosenbaum was considering Melancon. The same logic tracks in Eubanks versus State, which is a 2023 case. That's the possession with intent, felony murder. That's 317 Georgia 563.
Which I think the defense cites in there.
Yeah, so in response to that argument, the language that the state is asking for determining whether the state has proven these requirements in any given case is fact intensive and demands mixed considerations of logic and common sense. Justice, policy, and precedent, which are questions of causation for the jury to decide. That language comes from Justice Pinson's opinion in Melancon. That language is what Justice Pinson is telling the readers he's using to analyze the causation issue. Not that the jury should be instructed to use that. To instruct the jury to use justice, policy, and precedent, number one, opens the door to telling the jury that they are allowed to set policy on a case like that, on a case like this. So, for example, if you have a jury who thinks the gun laws in Georgia aren't stringent enough, they can make their own policy to impose criminal liability on someone else. What's more instructive is going to be Justice Pinson's concurrence in the 2025 case, Adams v. State, which is 322 Georgia 155. Justice Pinson in his concurrence states, based on Melancon, what the jury charge for proximate cause should be. And in that paragraph, he does not mention justice, policy, precedent, anything like that. Now in Melancon, after he gives that analysis, he then goes forward to analyze those different aspects when considering what happened in Melancon. So for example, he does look at policy by stating that you can be a mandated reporter, which is a very narrow class of individuals, and fail to report something that then leads to a child's death and only be subject to liability for a misdemeanor, as opposed to not being in this protected class of persons who is required to report certain things, and now you could be charged with murder in the second. And the examples he uses are you could be a social worker, a defects worker, someone along those lines, a parent, a babysitter who doesn't report something and based on that be subject to being prosecuted for murder in the second, as opposed to the policy consideration that's been granted on mandated reporters. And so he does analyze it in those terms, but he's not authorizing that it be used as a jury charge. The jury, when determining guilt or not guilt, should look at the evidence, not other considerations of their version of justice, policy, and precedent. That would suggest we would have to argue case law to the jury in our closing about Melancon and Rosenbaum and Adams and Eubanks and just down the litany of these cases.
From the state's request, is that sentence, the one you've just been discussing, is that the only offending sentence in their charge, or?
It's the most offensive. I'll say that.
I think the rest is pretty much the pattern.
is there anything in your?
I will say that, and the state's already agreed, the language about accelerating to death is we would agree is not necessary.
Is there anything in your request that you believe needs to be included somewhere? I mean, I don't, well, I'll just say that. Is there anything in your request that you're like, this isn't covered elsewhere, we need to include this?
Well, I think we definitely discuss foreseeability or likelihood of the death in a different way than the state does or the pattern.
So it's, the legal cause requirement specifies requisite foreseeability or likelihood of death happening in the way it did given the defendant's conduct, is that the?
That part, yes. And requiring the death in a way that was reasonably foreseeable, but that's kind of covered by probable or natural consequence.
Judge, I don't know that that's necessarily an accurate statement of the law. I think the way the pattern lays it out makes it clear what the jury is considering. I think once you introduce, so we're already dealing with proximate cause, which they're having to wrap their head around, and then we're bringing in cause and fact and legal cause and defining those and breaking them down. I think it's just getting confusing and kind of derivative. I think it's getting away from what it is that the jury's actually having to consider.
All right, I will kind of take a closer look at the pattern and what each of you's requested there. So, so if we didn't discuss it, it's otherwise fine.
Yes, sir.
Yes, sir.
We have state's request.
The contributing to
What are we talking about now?
That's what we're, yeah, right.
This is a new one, state's request here. Recordings of interviews. Was there more than, we fast forwarded during, investigator gets up, leaves the room, or?
We edited it, remember we had to edit it on the fly, because of
There was
statements
something,
made.
yeah.
So we had to edit portions out.
Judge, this is an issue that the state's come across with juries, I'd say repeatedly and increasingly, and I would say honestly the defense has as well, that the more and more we have things recorded, and the more we have the capabilities and navigating, redacting things from recordings played for the jury, it's the state's opinion that it's always going to be helpful to acknowledge it instead of sweeping it under the rug. If we can tell the jury that, hey, everyone's on the same page here, things weren't played, but don't hold it against either side.
And I think in this case, it cuts with both, Your Honor. The state fast forwarded it on our motion to get through inactivity, but the defense objected and it's partially edited. So they could hold it either one against either. So I think it's just better to, and safer to do it.
Just, we don't have a big problem with this.
Yeah, I don't see any harm in giving it, so I'll go ahead and give that request to charge coming in on redacted videos. All right, I realize we don't have a verdict form yet. And generally what I do in the verdict, generally I will also hold up the verdict form, kind of explain it to them.
And Judge, obviously, this is gonna be, regardless of the court's rulings, kind of a lengthy verdict form. Are you
Yes.
wanting the state to prepare that, or is your office preparing? Who do you want to?
Y'all have more staff than I do.
All right, happy to. Just wanted to make sure we weren't.
And we usually just have a blank. We, the jury, find the defendant blank, and I'll say fill in not guilty or guilty in accordance with your verdict there, so that you guys are aware. Unanimous verdict, court has no interest. And usually do cut down sympathy. And y'all tell me, because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against, surely we don't need all those.
I wouldn't think so, Your Honor.
No, sir.
All right. Tell me what you want left in. Or do you want me to just put a period after, before it starts that?
Period after prejudice, man.
Yeah, I mean, you are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. I can put a period there if y'all.
I think that'd be fine.
Or you can just put in the side in this case, you should not be influenced by sympathy or prejudice. Period.
I can put it there. Jobs.
No, I agree with Mr. Berry. I think it's fine to put it the period after sympathy or prejudice and then get rid of because of race. We want that out.
Okay. Sentencing is standard. Deliberations is standard. Anybody have any issues with any other portion?
No, sir.
No, sir.
All right, I'll have to take a lengthy recess to kind of sit through the lessers and some of the others. Is there anything else we need to address?
I think if we have time before the jury, it might be time efficient to address what goes back with the jury, that if,
Yeah.
I'll talk to defense counsel about that while you're, on recess.
You may be able to agree on some stuff.
One
We'll
will
talk, see if we can agree on a
Okay.
lot of this.
All right.
Paying attention to it.
Well,
I'm not sure what we can agree on, but that's
Brian
fine.
and I definitely agree on
I-
everything.
I'm not going to stand you.
Okay, we'll take a recess so I can work on that,
Yes.
I know that's important. I would give the pattern lesser charge, lesser offense charge, 16011.
Yes, sir.
Just straight from the pattern. All right. I'll put in a heavy lift.
Doing it fast and everything. That's the vibe I got. We can't tempt it.
Yeah, that's fine. Things are good as that.
Yeah. Yes.
All right.
What did I just agree to?
Brian said, I think we feel a lot more should go back than it was at least, than Mary feels. If y'all want to tell us what you don't, I think
Oh, exhibits.
it's up to y'all to go back to the jury. You can do that now, so,
Yeah.
God knows,
We can do
or
that.
something.
Why?
Yeah, if y'all want to kind of go through it, I think these facts records, I'm pretty sure we would agree to, with the vast majority of the other stuff, I think our position would be this. So if y'all want to kind of
We have
parse
some
through what you're
objections
doing.
we're gonna make about text messages and things like that,
Okay,
but I know what the case law says.
right.
It's more of a,
Pretty clear, yeah,
we're trying to anticipate
right.
a change at some point in the law, but
Sure.
we will acknowledge the case law is where
Fair.
it gets us on that.
We prepared the PowerPoint without headings right, so all the
Okay.
content of the PowerPoint without any sure she's gonna wanna cut specific stuff out before her closing.
Oh, no, I use it
Yeah, I was
for,
gonna pee in the
body cams and stuff like that, just to get a general idea, but it's messed up all over the place.
I mean, there's certain things that we use in our,
I'm
but
sure.
it's just not.
It's a good guide, but it's not close to being accurate that I could use it in court. Yeah, no way.
I'm not worried about my job at all. They started talking about that mess 20, 30 years ago, talking about it taking our job from
Right.
them.
No, it's not close to being there.
I tried utilizing stuff, and not it's easier for me just to do it myself.
Oh, yeah. Yeah.
Human interaction is so much more accurate.
No, and you can't.
When you have a competent human.
It does a terrible job when people talk over each other, which is most interactions in our job.
It happens
Yeah.
all the time.
Mhm.
See, we're doing it right now. I did that on purpose, actually.
You are correct. No, you cannot sort people out.
Because that's
You'll just
human
get a
nature.
paragraph.
It's human nature to
Mhm.
talk, over someone. Yeah, that was intentional. I'm not that way. I like to prove points.
Good job.
scared.
I'm not sure the door is closed on some further argument or clarification. These are the dangerous waters. That's why I wanted to get this on Friday, but we didn't. So let me start with the directed verdict for counts 9 and 21. I do think it's the directed verdict required. I'm going to cite Jones v. State, 304 Georgia 594, 304 Georgia 594. So grading the directed verdict on counts 9 and 21. As those victims did not testify. I think a lesser included is appropriate on the murder in the second degree, those being the involuntary manslaughter charges that were requested, both lawful act and unlawful act. Ms. Daniel, I know you cited Castro, and I'm going to confess I had to try and get through some of this quickly, though I wasn't very good at it. In Castro, the defendant was convicted of second-degree murder and cruelty to children in the second degree, and the court said we conclude that there was some evidence that Castro Moran was guilty of the lesser included offense of involuntary manslaughter, and the court erred in failing to charge that.
And Judge, I brought up Castro more in the context of the language that in order to have the lesser included,
Right.
There has to be some evidence of it. And like I said, there weren't a lot of, or any cases that follow, obviously this specific pattern, but
Sure.
It was more the reasoning used by the court versus the holding in that case.
In as much as it was error not to give the involuntary manslaughter lesser charges on the murder in the second in Castro, which is 356 Georgia Appeals 248, I am going to charge the lessers of involuntary manslaughter, so that's counts 1 and 3. Declining or not charging the lesser of contributing to the delinquency of a minor for any of the counts. And I'll just cite State versus State 309 Georgia Appeals 785, Slack v. State 265 Georgia Appeals 306. Declining to give a lesser contributing to the delinquency of a minor. Also declining to give the furnishing a firearm. My side Schuler 195 Georgia Appeals 849, and really, Ms. Daniel's arguments, there's a difference. The legislature's decided there's a difference in a pistol and a rifle as far as furnishing those to children. Declining to give the furnishing a firearm as a lesser for any of the offenses either. And of course, your requests are noted for the record. Now, so this is on reading the indictment or not, and I know both sides just sort of deferred. So Goss v. State 255 Georgia 678 says trial courts courts are not required to read the indictment to the jury. And it cites Benefield. In Benefield, the court found the jury was aware of the evidence and had the indictment with it during deliberations, and thus the trial court did not err in failing to read the indictment. The indictment was either read in whole, as is in jury selection, to one panel, or was broken down into groups listing various victims for other panels. So is there any objection to me just informing the jury what the charges are? 2 counts of murder in the second degree, 2 counts of involuntary manslaughter, and then telling them you will have the indictment with you during deliberations to refer to.
No,
If anybody wants me to read it, I'll read it.
I think it makes more sense that way anyway, because you kind of group them, which is more easy for the jury to digest.
Mr. Hobbs, Mr. Berry.
The only thing, Judge, since you're agreeing to give the lesser included, I think on 5 and 7, I don't know how you want to handle that. You just want to put it on the verdict form, or tell them about it, put it on the verdict form. I'm not sure how you want to handle it.
Yeah, I can tell them you will also be, when I tell them murder, the second degree, 2 counts, you will also be considering a lesser included offense, or offenses. So that would be my intention to tell them. And then, of course, it'll be addressed with the verdict form. All right. Coming to the part I haven't fully resolved is the proximate cause. So if you look at the pattern for proximate cause, the basic things that have to be, the jury has to be told that the defendant's criminal conduct has to be the proximate cause of the injury or death. And then to prove proximate cause, the evidence must show that the conduct played a substantial part in bringing about or causing the injury or death. Must also show, the evidence must also show that it was reasonably foreseeable or occurred in a reasonably foreseeable way. And defines reasonably foreseeable as the direct result of the defendant's conduct or a natural probable consequence, which defines that as one that a reasonable person would think is likely, if nothing unusual intervenes, and it defines intervening act. So we get all of that with the pattern, and I think I just want to be careful, charging the pattern and then charging each side's request or portions thereof that are kind of duplicative. Now I can say, so I think it's page 11, it might be also page 10, the state's request, proving the defendant caused the death of another human being requires proof of proximate cause. So that paragraph, up until the point where we get determining at the bottom, determining whether the state has proved these requirements that Mr. Hobbs was pointing out, that paragraph is straight from Melancon, which was cited verbatim by Benson and Adams.
Yes.
So, I certainly think that that is appropriate language. I don't know, I can use the word usurp, it kind of usurps some of what's in the pattern. You don't need to tell them the pattern and this. I don't know that it covers everything that we need to cover. It doesn't address intervening acts. I do agree with Mr. Hobbs that that last sentence would not be charged. So I guess I'm open to more argument on what y'all think is appropriate for meshing mean, I can read just the pattern, but, you know, I do think this language from Melanchon's appropriate, which means I would cut out where it kind of covers the same ground as the pattern. But I just, I'm open to suggestions here.
Well, the language that comes from Melanchon seems to be less confusing than really the pattern. The pattern's much longer, obviously. And it covers all of the same language, just much more concise.
So I would need to include in, because what's not covered in that is the intervening act, which I could then take from the pattern unless there was, looking at Melanchon to see if there was, you know, Melanchon has some other language, as when the intervening act was undertaken by someone other than the defendant who could reasonably be expected to take that action in response to criminal conduct. I'd have to pair that with something else. Having to prove whether the intervening act itself was a natural or probable consequence of the defendant's conduct. The language that we have in our packet from Melanchon just doesn't address the intervening act. But like I say, I could charge what I'll just call the Melanchon language as the first part of proximate cause, and then charge the pattern on the intervening act, which I think you'll see that starts with a bracket on page 10, if the evidence raises the issue of an intervening act.
The way I understand it, Your Honor, you're going to start with the state's request proving all the way down to not merely a possible result, taking off the last sentence. And then going to the top of the page, there may be an intervening act between the
That sounds right. Yes.
and then taking out or if the defendant's conduct materially accelerated the death.
Yes. And I would charge, I guess, at the very beginning of 14160 to find the defendant guilty of murder in the second degree, cruelty to children, involuntary manslaughter. Actually, I guess every count, including the reckless conduct here, the state must prove.
Should you want to take out the individual charges, say that to find the defendant guilty, the state must prove?
Could say that. I mean, it
Because
covers,
it's basically every count.
for the record, Mr. Apalachee has said yes. So I think that is probably adequate and safe unless somebody disagrees.
Nothing to say, no.
Yeah, 1 second, Judge.
Sure. one other thing, if you look at, it's somewhere just above proximate cause, the involuntary manslaughter, lawful act, unlawful manner. So the pattern stops after, so you got the three numbers, and then you got to prove involuntary manslaughter, state must prove the defendant acted with criminal negligence, and then the bench notes, you have to define criminal negligence, which I would have already done. But this stuff that's below that is down in a bench note, and it appears, I don't know why it's there. That's the reckless conduct language that pairs with the other form of involuntary manslaughter, and we generally don't ever tell a jury what's a felony and what's a misdemeanor anyway.
I think it's confusing, or could be confusing, Chris.
I'm sorry, just starting.
Where it says the state must prove the defendant acted with criminal negligence, what I would add is, which has already been defined for you, because I did that a couple of charges ago. But then what's below that, I don't know why that's there. It's actually, it pulled it up from a bench note. It's not actually part of the pattern charge or the law for lawful act in an unlawful manner.
So you're just gonna say as already defined?
Yes, sir. I just want to make sure I didn't miss anything. So Danielle she'll print a clean final version for each of you. Page, I think it's 7, 141-12, presumption and inferences. I've got concern about that charge because usually that is something that would go with intent. And we've taken the intent charges out because these are all criminal negligence charges, or some form of criminal negligence. So I'm inclined to take that out. It worries me. It really is in the intent section, because we're generally talking about intent crimes, and here we're talking about negligence. I don't think the state loses its argument, because they're going to get the natural and probable stuff with foreseeability in proximate cause. So since we've removed the intent from the other ones, I'm going to take it out here. See if I have questions, and I know you don't have your final version, but I'll give it to you. What I will probably do, since I know closings will be lengthy, is just take a break after the closings. Let everybody look at that final packet one last time, just to make sure I don't say something that's error. Any questions?
No, Your Honor.
All right. So as far as I know, the jury's not here yet, and if y'all need any, additional time, let me know. It's okay if they sit there for a little bit.
Judge, during the break, I had an opportunity to go through most everything that the state has. We do have some objections to certain items. I don't know when you want to take that up.
Yeah, normally I would do it now, but I want to make sure we get this done, and we can come back and handle that after closings and charge. Okay, so we'll do it, of course, but let's get this, the dust set up here. Anything else?
No, Your Honor.
Thank you.
try to be less than that, but just in case.
You need it.
We have a draft of the indictment, I mean, the verdict form. We have it here. We've added something to the one we showed them. I would like it back though, so I can use it.
I have more copies.
Oh, wait, no, never mind. And also, would it be possible to take a break after Mr. Berry's closing? We'll have been going a while, just like a bathroom break, and I want to set up himself for second closing.
Okay.
And then also, are you intending on us doing a redacted indictment, or you just want to tell the jury not consider those two counts?
What's everybody's thoughts on it?
Whatever the court wants.
Does the state have a preference?
We don't really feel strongly either way, Your Honor.
I'm sorry, Brian's having to interpret for me today because I can't hear out of the left side of my ear. So I have to look back and forth.
So, the verdict form, of course, goes count 20, count 22. I would probably prefer to give them a redacted indictment, and I will, if I can remember, will tell them, we understand that there are two counts that are not in this, just so that they don't send their first note out going, where's count 21? Yeah, quick look, I think the verdict form's fine. Did the defense have any issues with it?
No, Your Honor.
Okay, you wanted that back in Sprose?
I know, I have a copy. I'll keep the original.
Yeah. All right, are y'all ready for them?
Yes, Your Honor.
Sir,
Bring them in, Brooks.
Yes, sir. Yes, sir.
All right, y'all, we see it. Everybody happy with their chair? All right, so ladies and gentlemen, we are at the point of the trial where closing arguments are about to be given. Because the state has the burden of proof, they have the right to give an initial closing and then a final close after the defense. The defense just gets the one closing. What we will do, I do expect them to be pretty lengthy. So what we will do is the state will give an initial close and the defense will give a close. We'll take a short restroom break and then come back for the final close, and then I'll charge you on the law. All right? Ms. Brooks?
"41 seconds. On September 4th at 10:22 in the morning, Colin Gray opened fire in Apalachee High School for 41 seconds. Those 41 seconds forever altered the lives of the students of Apalachee High School, their parents, and everyone in this community. At 10:22 a.m., Christian acted and became a hero. He attempted to push the shooter out of his classroom, and when he was shot, Christian's last act on this earth was to shut the door to his classroom to protect his friends. In Miss Ryan's room, the teachers and students acted. Ronaldo ensured the door was barricaded, and Landon held Taylor's hand when she needed someone. Ariana tried to keep Taylor awake, and Miss Ryan attempted to put a tourniquet on Natalie's arm and comforted her. Miss Irmy acted. Her last act on this earth was to push her door shut to protect her students. When the shooting started, Coach Aspinwall acted. He went outside his classroom to see if he could help. Coach Phoenix acted. After being shot, he crawled back into his room and used his last bit of strength to shut his classroom door to protect his students. Valerie Lancaster acted. She used her training from Girl Scouts and stopped the bleed to save Coach Phoenix's life. And Sweet Mason, he didn't even have the opportunity to act. On September 4th at 10:22 a.m., SRO Donovan Boyd yelled into his radio, "Active shooter."
Active shooter. But an active shooter at Apalachee High School.
And at that moment, every law enforcement in Barron County and every law enforcement officer near Barron County acted. 58 agencies and 400 law enforcement officers came to Barrow County to answer the call for help. Within a minute of hearing those first shots, SROs Boyd and King took the shooter into custody and saved Zane Zinni's life. He was in that last hallway seconds from being shot by Colin Gray. Sheriff Judd Smith and Lieutenant Wilkerson acted. Sheriff Smith was one of the first responders and helped get Natalie to EMS quickly. And Lieutenant Wilkerson did everything he could to save Miss Iramy's life. And the incredibly quick response by EMS and law enforcement saved the lives of Coach Phoenix, Natalie, Taylor, and Melanie. Ladies and gentlemen, at the end of those 41 seconds, the sense of security that this school and this community once had was shattered. But also in the aftermath of those 41 seconds, a community united, heroes emerged. Parents from all backgrounds came together on the football field to try and find and embrace their children. And every person in this community wanted to know one thing: who did this and how did this happen? Everyone except for that man, the defendant, Colin Gray. He was not asking that question because he knew exactly who had done this and how this happened.
God. I knew it when my little girl just texted me. She's in middle school. She said, "We're in lockdown." I'm like, God almighty, please tell me brother didn't do something.
Why do you?
In fact, that man was the one person who could have prevented this mass shooting. He was the one man who ensured that Colin Gray had the tools he needed to commit mass murder. Ladies and gentlemen, that man and his son are both responsible for the immense suffering that occurred on September 4th. The blood is on their hands, and the defendant needs to be held accountable for his actions that led to the murder of 4 people and numerous other injuries, both mental and physical. I know this case has had testimony that was difficult and upsetting to hear, but I want to thank you again for your service as jurors. I have 2 opportunities to speak to you, like Judge Prim just said. After defense counsel gives their closing argument, I'll come back before you and explain why the evidence has proven the defendant guilty beyond a reasonable doubt. So right now, I'm going to briefly go over some of the law that the judge is going to give you to help you put some of the evidence in context. One thing he's going to talk to you about is the elements of the crimes that the state has to prove beyond a reasonable doubt. The defendant is charged with 29 crimes in the indictment. All of these crimes were committed in Bexar County. Apalachee High School is in Bexar County. The defendant's house, where he gave Colt access to the rifle and ammunition, is in Bexar County. So the first charge we're going to talk about is murder in the second degree. The defendant is charged with 2 counts of murder in the second degree for Mason and Christian, because they were the 2 children that were killed. To prove this, the state must show that the defendant caused the death of another human being, irrespective of malice, by committing the offense of cruelty to children in the second degree. When a child dies during the commission of cruelty to children in the second degree, then that is murder in the second degree. This is not malice murder. That's a completely different crime. No malice is required for second degree murder. And that means that the defendant did not have to intend for Christian or Mason to die. The state, however, does have to prove that the defendant's actions were the proximate cause of these deaths. And that is that his actions played a substantial part in bringing about or actually causing the deaths, and the deaths were reasonably foreseeable. For the first prong, at the age of 14, Colt could not legally buy a rifle or ammunition. He was too young. He also was too young to even drive to buy a firearm illegally. But for the defendant providing his son with a rifle and ammunition, these deaths would not have occurred. If you find the defendant guilty of cruelty to children related to Mason and Christian, then you have necessarily found that the defendant's actions played a substantial part in causing their deaths. As far as reasonably foreseeable, the state has to prove that these deaths weren't a remote possibility, but something a reasonable person could see happening. I like analogies, so I'm going to use a few throughout this closing. It's not to be flippant, but it's to try to explain the legal wording in a context that's relevant or more easily to understand. So here's my first one. Think about road signs, like the one that warns of falling rocks from a cliff. If you drive by that sign, you may not know exactly when or what type of rock is going to hit you, but you're on notice that if you drive by a cliff, you might get hit by a rock. Warning signs make something reasonably foreseeable. And ladies and gentlemen, we'll go through all this evidence in the second closing, but there were months and months and years of warning signs leading up to September 4th. Any reasonable parent, any reasonable person would have foreseen that Colt would harm somebody. Even 13-year-old Jenny Gray saw this coming. Jenny told the defendant, "But I think we are thinking the same thing, and I don't want to talk about it over text." And the defendant's response was 10-4, because he certainly saw this coming too. He is guilty of these charges. Next, we have 20 counts of cruelty to children in the second degree. To prove this charge, the state has to prove that the defendant caused cruel or excessive physical or mental pain to a child under the age of 18 years through criminal negligence. For the first element, the defendant caused this pain by consciously disregarding a substantial and unjustifiable risk that his act of allowing Colt Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition, after receiving sufficient warning that Colt Gray would harm and endanger the bodily safety of another. And thereafter, Colt Gray did shoot at and shoot children. That's what is in the indictment, and I know it's lengthy, but that is what the state has to prove. So to break this down a little, I want to first talk about the act that the defendant committed. The defendant gave access to a semi-automatic rifle and ammunition to his son, Colt. His son, who was a minor over whom he had custodial responsibility. Now, Colt lives in the defendant's house. The defendant bought him the rifle. The defendant had the ability to take that rifle away if he wanted to. The defendant gave this access to Colt after he received sufficient warning that Colt Gray would harm and endanger the bodily safety of another. Now, the defense in opening misled you about this part of the law. They said we had to prove that the defendant unequivocally knew that Colt would harm someone. This is not what the law is. This is what they want the law to be. But what the indictment says, what the law says, is that we have to prove the defendant received sufficient warning that Colt would harm someone. Sufficient warning. Here's another analogy. If you see a weather report saying there was a 70% chance of rain, then you've received sufficient warning that it would rain, and it's your responsibility to bring an umbrella. When looking at the evidence in this case and deciding this case, keep in mind what the actual law is and what the state has to prove. Listen to the judge as he charges you on the law. Remember, it is you, the jury, who decides what is sufficient warning. And you've heard the evidence, and you know that the defendant was sufficiently warned that his child would hurt someone. I also want to point out that the judge is going to instruct you that when a count on the indictment charges that the defendant committed a crime in more than one way, you may convict him if the evidence shows that the crime was committed in any of the ways on the indictment. Essentially what that means is if there is an and in the indictment, it means or. So for example, in cruelty to children, we charge would harm and endanger the bodily safety of another. But all the state has to prove is that it would be would harm or endanger the bodily safety of another, not both. So if we prove one, then the defendant is guilty of that charge. And that goes for any time there is an and in the indictment. It means or. When the defendant gave Colt this access to a firearm and ammunition, he consciously disregarded a substantial and unjustifiable risk that Colt would hurt someone. The term conscious disregard is defined as rising to the level of a gross deviation from the standard of care a reasonable person would exercise in this situation. And finally, the harm, as we know, occurred when Colt shot at and shot children at Apalachee High School. That's the first element of cause for cruelty to children. The second element is cruel or excessive physical or mental pain. The state has to prove that each of the victims listed in the indictment suffered cruel or excessive mental or physical pain. I know those kids' testimonies were heart-wrenching and difficult to listen to, but we had to call them to testify in order to prove this element. Each and every one of them had cruel and excessive physical or mental pain. You have Taylor, who still walks with a limp, has had countless surgeries, sleep terrors, and anxiety. Natalie does not have full use of her hand and has PTSD. Melanie took 6 months to recover, missed her soccer season, and still has images of that day stuck in her head. Nautica can no longer play sports. She had nightmares and thoughts of suicide. Jackson has been unable to go back to school because of what happened, and he had to give up something he loved, the marching band. Ronaldo became more aggressive, had bad dreams, and could not hug his own mother. Hayden has panic attacks and lives in fear that this will happen again. William sent his family a text message after the shooting telling them he loved them and that he thought he was going to die. Kendez has nightmares and spent a year and a half believing that he had left the door to his classroom open. Marquez constantly thinks about what happened that day and has even lost his love of sports. Brittany is scared easily and is triggered by loud noises. Michaela is traumatized and is scared to stay home alone. Jalen has more anxiety, and Martin is constantly looking at doors, afraid of what might happen. Ariana started anxiety medication and has intrusive thoughts of Christian. The second element is met. And of course, for the third element, you heard either the students or Ms. Ryan testify that they were all under the age of 18. The final element for cruelty to children in the second degree is criminal negligence. That is defined as an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured. The defendant is not charged, again, with purposely or intentionally bringing about the harm, but with recklessly doing it. And reckless disregard for the safety of others describes exactly the defendant's actions in this case. So those are the two charges that are related to the child victims. The next two charges we have are related to the adult victims. That is involuntary manslaughter and reckless conduct. The first charge we're going to talk about is involuntary manslaughter, which is the corresponding charge for adults for murder in the second degree. The defendant is charged with 2 counts of this against Coach Aspinwall and Miss Irami. In order to prove involuntary manslaughter, the state has to prove that the defendant caused the death of another person without intending to do so by committing the offense of reckless conduct. Again, the defendant did not have to intend to kill these people, but if someone dies during the commission of reckless conduct, then that is involuntary manslaughter. For all of the adult victims, there's also a charge of reckless conduct. And again, this is the corresponding charge to cruelty to children when the victim is an adult and not a child. And it is laid out the exact same way as the cruelty to children charges. In order to prove these counts, the state has to prove that the defendant caused bodily harm or endangered the personal safety of another by consciously disregarding a substantial and unjustifiable risk that the defendant's act or failure to act would cause harm or endanger the bodily safety of another. And clearly the defendant's actions in this case constitute reckless conduct. Before I move on from discussing the charges, I need to talk to you about something called lesser included charges. What that means is the defendant is going to ask you to either find him not guilty or find him guilty of only a lesser charge. He wants you to do exactly what he does every time he talks. Make his actions seem better than they actually were. On this verdict form, which you'll have with you back in the jury room, it'll have what the state indicted the defendant at the top, and then under it, it'll be the 2 lesser included charges for murder, and then there'll be 1 lesser included for involuntary manslaughter. I'm going to start with the first lesser included for murder in the second degree. For that one, the defendant wants you to find him guilty of only the lesser included charge of involuntary manslaughter, like we just talked about for the adult victims. He wants you to find that Mason and Christian died in the commission of a reckless conduct instead of a cruelty to children in the second degree. The only way you can find this lesser charge is if you find that Mason and Christian did not suffer cruel or excessive pain. Since Mason and Christian are under the age of 18, that's the only additional element that separates cruelty to children from reckless conduct. To find that Mason and Christian did not suffer cruel and excessive pain, you would have to put aside all logic and common sense. These children paid the ultimate price for the defendant's actions, and there is no argument that their pain wasn't both cruel and excessive. Ladies and gentlemen, when you go back to the jury room, read the indicted charge. Read what murder in the second degree is on the indictment. If you find him guilty of that charge, leave the other 2 blank. And remember, if you find the defendant guilty of cruelty to children in the second degree, because Mason and Christian died during that act, that man is guilty of murder in the second degree. The law is that simple. For involuntary manslaughter, the defendant is also asking that you find him guilty of the lesser included charge of involuntary manslaughter lawful act. What he is charged with currently on the indictment is involuntary manslaughter unlawful act. This is also going to be a second lesser included of murder. So for second degree murder, it'll have involuntary manslaughter, unlawful act, and involuntary manslaughter, lawful act. And then for involuntary manslaughter, it is gonna say the indicted charge is unlawful act, and the lesser included is lawful act. The judge is going to instruct you that this version of involuntary manslaughter means that someone dies in the commission of a lawful act in an unlawful manner. An example of a lawful act in an unlawful manner is building a porch without a permit. It's lawful to build a porch. It's unlawful to do it without a permit. Ladies and gentlemen, what this man did is not the equivalent of not getting a permit. This man in no way committed a lawful act. Buying a gun for the purpose of transferring it to your 13-year-old child is illegal. A reasonable gun owner would secure his weapons just because he had children. It is certainly a gross deviation from that standard for the defendant to let a child like Colin Gray have a rifle in his room. For the adult victims, find the defendant guilty of the indicted charge of involuntary manslaughter, unlawful act, and leave lawful act blank. And for the child victims, again, find him guilty of murder in the second degree and leave the other two blank. Essentially, the defendant wants you to convict him only of something that is barely a crime because it was committed doing a lawful act. Don't let these lesser included charges confuse you. The defendant is guilty of what is charged in the indictment. The defense claimed in opening statements that if you find the defendant guilty, it's a slippery slope, and parents will start getting charged all over the place for crimes their children committed. Ladies and gentlemen, the defendant is not charged with these crimes because he is Colt's parent, because he shares his last name. He is charged with these crimes because he shares the blame. Think about it this way. Our children do risky things all the time. For example, a 16-year-old driving a car is inherently risky, but parents let their children drive because this is a justifiable risk. A parent does not commit a crime if their 16-year-old gets in a car accident and kills somebody. However, if you give your 16-year-old a six-pack of beer, watch him drink it, see him fall over the place, help him up, then him driving, now that's become an unjustifiable risk. If you disregard that risk and give your child the keys to the car and watch him drive off, and then he kills someone, then yes, your actions combined with your knowledge are criminally negligent and they're reckless, and you're guilty of murder in the second degree or involuntary manslaughter depending on the age of the victim. But that's because of the parent's own actions, not just because their child did something. After seeing sign after sign of his son's deteriorating mental state, his violence, his school shooter obsession, the defendant has sufficient warning that his son was a bomb just waiting to go off. And instead of disarming him, he gave him the detonator. Charging the defendant is not a slippery slope. It's reasonable, it's common sense, it's justice. The last part of the law I'm going to go over with you is reasonable doubt. The judge is going to tell you that the state has the burden to prove all of the elements charged in the indictment beyond a reasonable doubt. Reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. When you seek the truth, you do not abandon your common sense. Use your common sense when you are deciding this case. Think about it like this. In Wheel of Fortune, there's a moment where contestants know exactly what the phrase is, even if all the letters are missing. The moment you know that the defendant is guilty, even if there are some missing letters, that is the moment that you have found beyond a reasonable doubt. Now, the defense attorney is going to get up here and do his job and try to convince you to acquit the defendant. then I'll come back before you and do my job and explain why the evidence has proven him guilty beyond a reasonable doubt of all the charges. And as you listen to these final two closings, keep in mind what your job is. Your job is not to look for doubt. Your job is to honestly seek the truth. And in this case, if you look for the truth, you will find that there is no doubt that the defendant is guilty of all charges.
Thank you, Your Honor. Yeah, get something off.
Sir? Yes.
Good afternoon. I want to thank you for your service. It's people like you who take time off from their work, from their daily lives, to come to court and be sure that our justice system is preserved. And for that, we want to thank you. You do this. You don't grumble about it. You come in here and you do your job. We appreciate that. A good jury is a cross-section of the community. Each one of you comes in here, you have different jobs, you have different religious backgrounds, come from different places, but you all share different experiences. And that's why it's good to have a cross-section of people, because each one of you has something to tell the other. Each one of you can look at a case a little differently than the other. The state gave you some charges that we feel the judge will read to you. I want to go over just a couple more of those, and then we'll get into what we believe the evidence showed or not showed. I think the cradle of American liberty is the burden of proof. Very simply put, the state has the burden of proving this case to you, not to a reasonable doubt, but beyond a reasonable doubt. That's what makes our system work. Presumption of innocence. Colin Gray, when he came into this courtroom, was presumed innocent. That presumption of innocence stays with a person until it's overcome by competent legal evidence. Reasonable doubt. Brooks went over a little bit about reasonable doubt. But simplified is it's a doubt for which you have a reason. It can be because of a conflict in the evidence. It can be because of a lack of evidence, or any number of things. If you are not satisfied and your minds are wavering and you're saying, well, you know, I didn't hear about this, I've got a problem with that, then that's a doubt of the law and you should acquit. Court's also going to tell you about grave suspicion. Grave suspicion, it merely puts upon a defendant a grave suspicion of a crime charged, or merely raises a speculation or a conjecture of the defendant's guilt, is not sufficient to authorize a conviction. Speculation and conjecture is something that we have heard in this case. A lot of speculation. Why didn't you do this? Why didn't you do that? A lot of conjecture. It's important to keep that in mind. I want to go over just a minute with you the indictment. I'm going to try to simplify it as much as I can. I know Ms. Brooks went over it initially. But in counts 1 and 2 of the indictment, to simplify it, you're going to have to find cruelty before you can even get to the murder in the second degree. You're going to have to do that for counts 1, 2, 3, 4, and basically 5 and 6. You're going to have to find an underlying charge before you ever get to the main charge. There's a lot of terms here, a lot of things that the court's going to tell you. You're going to hear criminal negligence, you're going to hear proximate cause. All of these are important for you to understand when you're plugging in what the state has said in their indictment. And this is what they say. That criminal negligence in the child under the age of 18, cruel and excessive pain by consciously disregarding a substantial and unjustifiable risk. And that this act of allowing Colin Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition. Let me stop here, because Georgia law does not require a gun be locked up or ammunition be locked up. So that's not a criminal act. Having a gun in the house, having ammunition in the house is not a criminal act. So don't forget that that's not the case. That's not the criminal act, supposedly, that they're indicating. And in the indictment, they indicate that Colin Gray knew that this would happen. Now, that's real important, because that really is the key to this case, is what did he know? Did he know that Cole would do this? What evidence do they have that points to he would do it? That's what they've alleged in their indictment. And if you'll remember, the district attorney in his opening statement told you he knew it. He said he knew that this was going to happen. How did he know it? Got a child with some issues, but how did he know it? Was there anything that showed that he knew it? That there's a gross deviation. What's gross deviation? That's something that you're going to have to figure out. Was this a gross deviation where he allowed his son to have this gun? It's not illegal to have. These are things that you'll have to look at in the indictment and have to make your decision about. What a horrible thing for these children to have to go through. Something that no child should have to endure. The loss of a child by a parent is difficult. The loss of a husband or a wife in a situation like that is horrible. And we're not saying it's not. First part of this case, they went through all of the horror that these children went through. But that's not really what this case is about. It's not that you decide this case on emotion. You have to decide this case on facts and the law. It's the only two things. You know, when you took your oath to be a juror, an oath is a promise. And you promised us in that oath that you took that you weren't going to be biased, that you were going to look at the facts and circumstances and render a fair verdict based on the law and the facts. I know that's hard in a case like this. You've got a lot of pressure. Everybody in this community wants to see somebody go to jail other than this young man right here. This is the person who went into the high school and shot and killed 4 people he didn't even know and injured scores of others. This is the person who needs to be punished. He made a conscious decision to do this, a secretive decision. This is the person that should be punished. He's being charged as an adult, which means he suffers the same consequences as an adult would if he were charged in the case. We were not able to have him testify, nor was the state. The reason is that we couldn't call him because his attorney would not allow us to do that. It would be hearsay if we attempted to do that. Had he been tried first, maybe we could do that. Maybe we could get some answers to some of the questions that still linger for all of us. Who is Colin Gray? We found out that he was a smart kid, obviously. He was able at 11 years old to get behind a firewall at school and do searches. I wouldn't be able to get behind a firewall at my age and do any searches. So at 11 years old, that's pretty good. So we know he was a smart kid. We know that he kept dark secrets. How do we know that? Because he was on that computer. He was on a computer with a dark web. We know that because Jenny told us he had a number of different accounts. He was always changing his password. And this is where he got information about these individuals that you see on this board. Nicholas Cruz, among others. He was secretive in that he didn't tell everybody what he was doing. He certainly didn't tell his dad. You're not going to find one email or one witness that tells you Colt told his dad he was going to do a shooting. Look at all of the evidence that you have over here and over here. You got 60,000 pages of text messages. 60,000. Not one of those text messages informs him of anything that he's going to do to harm anybody. We know that Colt had some mental issues. We're not trying to get around that. But what was the extent of those mental issues? We don't even know today, as we are here, what those mental issues were, even today, over a year after this incident. And even if he had been taken to a counselor, as manipulative as he was, do you think he'd be able to get around that counselor, convincing that he was fine? Was his parents that were the problem? They thought he suffered from anxiety and depression. Had these volatile temper tantrums. As I said, the first days of this trial were pretty emotional. An awful lot of evidence that you have to look at. But certainly we want you to look at it all. They're going to have to show that this was an anticipated and a reasonably foreseen incident on the part of Colin Gray. Well, who would be able to foresee that a 14-year-old is going to take a rifle, I don't know where it is, as big as it is, as heavy it is, and stick it in a book bag, get on a bus, come to school, walk down the hall, go to class, put it down on the floor, and not one single person sees it? How foreseeable is that? And on top of that, then we have, what is foreseeability in some other people at the school? At 8:46, Miss Harris sends an email. Got a kid in my class who's asking about school shootings. 8:46. Then, after her class, she goes to Ms. Martin's office, one of the people that she emails, and tells her, I believe I saw a gun. Did they shut the school down right then? No. It's 9:40. 23 minutes, Colin Gray is sitting in class before he leaves. They got 23 minutes to figure out where is this kid that's made this threat and maybe has a gun. They didn't find him. They don't take anybody that knows what he looks like. They didn't ask, what does this kid look like? They don't get a description of him. They go pull another Colin Gray out of the bathroom. Doesn't look anything like Colin Gray. Apparently, nothing was ever said about there being two Colin Grays in the same class. And during the time that they are pulling Colin Gray out of the bathroom, Colin Gray is in the same bathroom. Foreseeability. People miss things. School officials miss things. It's not unusual sometimes that people miss things. An hour and a half, Colin Gray was in the school with a gun, and nobody found him. A gun that takes 7.5 pounds to pull the trigger. The ammunition was hunting ammunition. It's an AR style. Not a machine gun. You don't hold the trigger down and it keeps firing. It's semi-automatic, like a 9mm or many other rifles that people purchase. Let's talk about the people that knew the most about Colin, his family. Debbie, his grandmother, told you that he was her favorite, his firstborn son. Told you that he was very manipulative. I think you saw that on the text. If he didn't get what he wanted, he would pitch a fit. Not like some other children. Don't get what they want, they pitch a fit. She told you about the comings and goings of Colt, Colin, and Marcy, and the other children. When they were there, and Fitzgerald, and when they weren't. She told you about an when Colt and his mother got into it. Mother slapped him. He broke a pane out of the glass door, slamming the door. And she called DFAX. DFAX intervened. This, they want to tell you, is a red flag, where Colt was slapped by his mother and he slammed the door too hard. There was an allegation that he was stabbing the couch. What Debbie told you, that Marcy lied, and she didn't know whether he did that or not. And of course, Colt denied to his dad that he did that. Told us about she didn't know, but we heard later while he was there in Fitzgerald, he'd cut his arm. Was that the last time he cut his arm? This is interesting. The state brought a picture up and showed it to Colin Gray. You're not going to see that picture. We don't believe that that's his arm. Take a look at the picture over there of him. There's no cuts on his arm. Let me tell you, if those cuts had been on his arm, the police officers, when they arrested him, they would have taken pictures of that. They took the other pictures of the upper arm several years ago when he cut himself. Why is that picture not in? Because they can't prove that it was his arm. Nobody else saw it. Debbie didn't see it. Marcy didn't see it. Jenny didn't see it. Coley didn't see it. Colin didn't see it. So where in the heck did that come from? Doesn't make any sense. She told us that she bought Colt a phone when he went back with his dad so that they could stay in communication. And that she talked to him a lot. That she came to Barrow County and to Jefferson County to see him almost every month. She purchased for Colt ammunition and clips. Why would she do that? Because she was glad that he had something that he enjoyed doing. Going hunting with his dad. Bonding with his dad. She was not displeased with him purchasing this gun back in December. Otherwise, she would not be purchasing all these items for him. And it's interesting, during the time that Colin and Colt were together in Jefferson and here, we didn't hear one thing about any altercations between Colin or Colt. One of the big things that they want to talk about is this May 23rd, when Jefferson County sent a sheriff's deputy out to the home. You got to view that video. When they came to the home, Colin, come on up on the porch. I'll get him out here. You talk to him. You didn't try to hide anything from him. Come out and talk to him. They talked to Colt. Talked to Colin. And Colin tells them, if there's anything to this, all the guns in the house are gone. At that time, Colt's gun had not been purchased. It didn't get purchased for about 7 or 8 months later. But the thing is, they want to say that that is a red flag that Colin should have known by them coming out there. But what did they say? You know what? We don't believe that your son did this. The follow-up phone call was the next day. And they told Colin, We don't believe your son did this. This came through some California website. It was in Russian. We don't know what this is. Never was there a follow-up. Never. Has there been one police officer or official that has ever told Colin Gray, your son is a threat and you need to throw the guns away? No. You didn't hear that, and you won't hear that because there wasn't any. Debbie tells us that, unfortunately, she was tied up by her daughter, Marcy. Marcy was on drugs pretty heavily, and she had the two children down there with her in Fitzgerald. DFACS took those children, and they called Colin and said, will you come and get these two children? He didn't hesitate. He didn't say, no, I don't want my children. He loved his children. He wanted his children. So he went down immediately and he brought them back. And because of that, Marcy was pretty upset. She had lost the two children. So what did she do? She wanted to borrow her mother's car. She said, I'm going to kill Colin and Colt. Now, if you're a 13, 14-year-old boy, and you hear that your mother wants to kill you, what do you think that does to you? You think you might not be real happy with your mother at that point in time? You think that you might think, you know, she might really do that. She might kill me. Debbie indicated that she helped Colin from time to time. She indicated that, and of course I'm sure the state's going to talk about the 8th grade, what happened in the 8th grade. But at the beginning of the 8th grade, Colt was in Fitzgerald. He was not registered. They attempted to get him in a virtual school. Didn't work out. Then he went back with his dad. As he testified to you, he asked his sister to help, asked Debbie to help, try to get Colt into a program, and actually believed that Colt was. Because you'll find some of these emails or texts where he's texting and saying, how's school going? You know, what are you doing class-wise today? And Colt is not telling him the truth. He's lying to him about doing the schoolwork. Debbie says that she got a call from Colt to come and get Marcy, because after Marcy got out of rehab, it was decided in the family, let's bring her back and see how that'll work out. She was there about a month. But during that month, she caused all kind of havoc. Debbie told us that she had to come up and retrieve Marcy because of an altercation between she and Colt. She also told us that she had come up here on the 28th and met with Lisa Butler. Talked to Lisa Butler about getting Colt into some therapy. You also heard on the 26th, Colt texts Debbie and says, if I do something bad, will you still love me? Of course, she texted back and said, sure. You know what? She never told Colin that. This is one of the problems. Things happen and nobody tells him. How's he supposed to get this? Through osmosis? People don't tell him things, how's he going to know? And Debbie says that while she's up here getting Marcy decides to put Colt on Zoloft. And she said that when she was here and talked to Lisa Butler, she talked to Colin about filling out paperwork to get the counseling. And he did that. And the state kind of poo-pooed on that, and they said, well, it took you 24 hours to fill out that paperwork on one page. It's not that he didn't do it. You're going to condemn him for waiting a day? This is kind of the way this thing is going. They want you to connect dots from the second grade for a 7-year time period and say, well, you should have known that he was going to commit a murder because he wrote some graffiti on the wall in the second grade, or because he went behind a firewall in the third grade or sixth grade. They want you to connect those dots for a 7-year time period. What happened to the other 364 days of the year? What happened to all of the other time period? They want to pick out these different things over a 7-year time period and say, you put them all together and this is what you got. But as a parent, you don't do that. She also told us that she thought Colin was doing a great job with these children. Now, Colin is pulling the wagon. He's working a job. He has 3 children, not just Colt, but he's got 2 more. Colt's not easy, but he's having to feed and clothe, pay rent, pay all of the bills that need to be paid. He's pulling the wagon. Nobody wants to talk about the other 2 children who are going to school, not being late, and doing what they're supposed to do. They wouldn't be doing that if it wasn't for him. He's the one that got them up, got them going, got them to school. The problem child is Colt, and he was doing the best that he could to figure that out. It's interesting, too, that Debbie never told Colt, you need to put these guns up. She never told him that. Let's talk a minute about Marcy. You've got an opportunity to hear her as she described herself. She's a good mother. I think we'd have to beg to differ on that. She told us, and really tried to make light of many of these issues. It seems with Marcy, nothing is her fault. Everything is somebody else's fault. And apparently she had no problem with Colt and Colin going hunting. Apparently she had no problem with Colt going to the firing range. And apparently had no problem with the gun being in and around the house. Because you're not going to find one single text message or email from her telling Colin to put the guns up. Your son is a threat. Not one. I had a big stack of emails and text messages. Not one of them. They had one conversation after Marcy was there and got into the altercation with Colt when she grabbed the gun and he took it back away from her. And that's when she said, "You need to put the guns up." That's the only time. It's interesting, too, that neither Debbie, nor Marcy, nor Jenny, nor Collie never saw any ammunition in Colt's room. There's one photograph that's in the group that shows some ammunition, a box of Winchester ammunition. Was that when Debbie bought it and then it got put up? Ammunition was kept away from the gun. The rule was no ammunition in the gun. It was in a different place. And a gun without ammunition is just a gun. Marcy told us, "I didn't see this coming." Here's the woman who is talking to Colt about school shooters. Here's the woman who knows that Colt has put $20 on Nicholas Cruz's account. Here's the woman who's doing searches of school shooters. Here's the woman who's watching documentaries, none of which she told Colin about. There's not one single email about that. The state's going to bring up this right after she was doing the searches. It was a 11 or 14-minute telephone call where the state's going to say it's interesting that right after she does these searches that they're talking on the phone. Neither Marcy nor Colin say that they were talking about the school shooting or looking up what happens to parents in school shooting. They were talking about the Saturday that she was going to come up. That's what they were talking about. If you remember, they were going to come up, she wanted to come up on Saturday and take Colt to Advantage. But that didn't happen. Didn't happen because Colin didn't want it to happen. He didn't want her to get up here and have another altercation, Colt have another altercation with the mother. Plus, it's a 4.5-hour drive down there. And a 4.5-hour drive back. That's 9 hours. So what did she expect? He's going to drive there, leave at 6 in the morning, and then drive another 16 hours total, there, back, and still have time to take Colt to Advantage. Doesn't make any sense. That was not going to be the plan. But as much as Marcy tries to throw Colin under the bus, she said to you, I didn't tell him about it. I didn't tell him about these searches. I didn't tell him about Colt's obsession with shooters. I didn't tell him about the money that Colt got from his dad that he lied about. Matter of fact, she laughed about it. And she says, I didn't see it coming. She talked about the email back in the 6th grade where Colt looked up how to kill your dad. Colt explained that to his dad. As you heard, there were a number of boys that were talking about it, and he just looked it up. We don't know whether any of the other boys got ISS like he did. We know that Colin wasn't even told about it for a couple of months. We don't know whether there were any counselors that talked with him at that point. We don't have that information. What else did Marcy do? Well, she keyed writing something nasty on Colin's truck, causing him to lose his job. Hard to get another job in the business that he's in. But he was able to get a good job, and he was making good money. And he was buying his children things. Not only Colt, but Jenny and little Colt. Just like most parents would do. The altercation that she had with Colt when she came back here after she had been in rehab, she told a different version than what Colt told his dad. And it's interesting that Jenny also said it was Mother who went and got the gun. So who would Colin believe? Jenny and Colt, or Marcy, who lies all the time? Marcy is the one that dyed Colt's hair blonde shortly before this incident. She believed that Colt had anxiety and depression. And she told you that she had talked to her psychiatrist about Zoloft. Why did she not talk to her psychiatrist about Colt? Why did she not say, he's having some anger issues, he's having anxiety, what do you think we ought to do? She never did that. It's interesting, too, that Marcy, when she was here, never said anything about seeing this collage of photographs that's been shown to you a ton. She never saw it. Debbie never saw it, which is interesting because she said, you remember, she came up here to clean up Colt's room. So surely, if it was on the wall when she was here, she would remember it. But she didn't. Marcy told us that everybody was on board with getting Colt therapy. She told you that Colt had said he wanted to kill his dad another time. But she also told you, I never told Colin about that. So how's he going to know if somebody doesn't tell him? But she says Didn't see it coming. And then she said, I can't picture him hurting anyone. It's the last thing that I would have thought. That's what she said. You heard from Jenny. Big difference when she came in to testify to you as opposed to the statement that we played. She told you when she came here in her testimony that Colt always kept his door closed. She also said that her dad asked to cover for him. Cover for what? Ask her to lie about what? He gave 2 long statements to police. He told them a consistent story about picture, consistently that there was one picture. He came back and said he was told that it was Nicholas Cruz. But what else? What else did she lie about? State didn't ask her. So let's go through what she said in her first statement. She said her father was a happy and energetic person. And we know that because of the text messages that he sends to the children, and you'll be able to look at those or talk about them back. He's always telling them that he loves them. He's encouraging them, especially Colt. He's encouraging them to go to school, do the right thing. You're a good young man. I love you. Encouragement from parents that you would expect. Not getting that same kind of encouragement from Marcy. She said about her mother that she was overbearing and annoying. When Colt got in a mood, he would instigate stuff. She told you about when he would get mad and he would rush at Colin, and Colin would bear hug him and hold him until he calmed down. And then she said something interesting. Colt would always apologize. He would always come back and say, I'm sorry. She said that her dad was close to getting him in therapy. And she told you about the burner accounts that Colt had. That he had numbers of accounts, and his dad did not know. She said specifically, Dad doesn't know anything about it. She said that Colt had talked with her about school shootings, but Dad didn't know. She never told Dad. She said Colt had been bullied. I think she felt like that probably was a reason that he had these anger issues. And then she said, the morning that this happened, I saw this book bag. And it didn't look right. I knew there weren't assignments that early. And when he left, I went in and looked for the gun. The gun wasn't there. But she didn't call her dad. She didn't call Colin and say, guess what? The gun's gone, and it looks like maybe Colt has it in a book bag. Didn't call him to tell him that. But she did call him after the incident, as well as Marcy. Marcy had been watching it, had been talking to the school. Marcy knew a lot, and she calls before the officers ever get there. And, you know, they played this segment here where Colin said, "I knew it." That doesn't mean that he knew that's what he was going to do. He knew it because Marcy had already called and Jenny had called. They're trying to push it to make something that really it didn't fit. Just like this text, the blood's on your hands text. It's interesting that that text comes when Marcy and he are in a problem and he wants her out of there. And he's telling his dad, she needs to get out of here. It's going to be blood on your hands because she's already said that she's going to kill me. So that's a problem. But shortly after that text, after he texts that, he texts his dad, "I like school. People here are mature. I'm enjoying school." What does that portray? I want to talk just a minute about Lisa Butler, too. On August the 13th, Lisa Butler met with Colt and Colin, and they were trying to figure out exactly what they needed to do with Colt, because most of the 8th grade he missed. So she's trying to figure out, okay, do I put him in 8th grade classes? Do I put him in 9th grade classes? Colin wants him to be in the 8th grade with Jenny. So they decide this is when your start date's going to be. So when they made that chart saying, oh, he didn't go to school here, he didn't go to school here, he didn't go to school here, it was not the starting date. He wasn't supposed to go to school during those times because the starting date was started later. And that's what Lisa Butler told us. She saw him again on the 26th when he came to her office with anxiety. She talked to Colin on the phone. She tried to call him, but it was the wrong number. Colt got him on the phone. His dad got him calmed down. But Colt told her about his mother, what his mother had done to the grandmother, and several other things about the mother being on meth. And so Lisa Butler had some idea at that point about what was going on with Colt. But she put him in, I think, a calm room or a safe room or whatever they call those things. They have them in school. An awful lot of kids with anxiety these days. They even had to make a room for kids with anxiety. And she said that on the day of this shooting, she had a whole bunch of folks waiting for her because of problems that they were having in the school. She said that she got a telephone call that morning from Marcy, explaining that she thought, because of a text message that she got, that Colt was going to be doing something at the school. They talked for about 8.5 minutes, close to 9 minutes, shortly before this started. She also told us that she had Colin fill out paperwork for Jade Baker to start therapy. You saw the letter that Jade Baker sent saying, I will meet with Colt the first part of next week. I think Colin believed that it was going to be on the 5th, which would have been a day later. Let's talk about Colin. When the police came to interview him, he cooperated. He gave them a statement immediately. He told them they could go in the house and search. He gave them permission to search the phones. He did everything that he could to cooperate, still not knowing exactly what and how this could have happened. He didn't have to do that, but he did. And then he gave in another statement the very next day. Didn't try to get a lawyer to go with him. Went by himself. Gave background history, told them whatever they wanted to know. Talk about the defects calling and him going to Fitzgerald to get the children. Now, does this sound like a parent that doesn't care? Does this sound like a parent who's just going to slough off his kid? He wasn't out running the road at night. He wasn't drinking. He wasn't hitting on his kids. He would come home and he would deal with the kids every night. And on the weekends, he would take them places. He did things with the kids. He wanted the kids to be happy. He wanted Colt to be happy. And he thought, and you probably will remember this, when he took Colt hunting and Colt shot his first deer, he told him going in, don't expect to even see a deer. But there he was. And he shot the deer, and he told you, that was one of the happiest days of my life, because Colt has accomplished something. He is going to have a bonding with me now over hunting, going to the target range. There's absolutely nothing wrong with going to the target range. There's absolutely nothing wrong with hunting. You don't have to put a gun in his name. As you remember, what Colin said was, I bought the gun at Christmas, but I told him, when you get to be of age, I'm going to give it to you. This is just for you to use. It's not yours until you come of age. He had rules about the gun. It's not loaded in the house. That if any of these rules are broken, the guns are out of here. Now, the state says, well, you know, you got these gun locks. You know, if a kid is motivated, if he's been victimized by this dark web, and we don't know exactly when all this dark web stuff started, but if he's smart as Colt was, you know what do you do with a gun lock? Take a big old pair of wire cutters, cut that thing off. Think that's really going to stop him if that's what he's intending to do? You think even locking up ammunition, he's smart enough to know, okay, when we go to the gun range, or when my grandmother buys me bullets, I'm going to stick a few in my pocket. I'm going to hoard up these things. If he really made the decision that this is what he's going to do, he's smart enough to have been able to do that. You think that would have really stopped him? Colin told you he never had a reason to believe that Colt would harm anybody with this gun. He had never told him anything about harming anybody with a gun. He had never threatened with a gun. It was a trust thing. It was a trust between he and Colin, because they needed that. They needed that trust, because he wanted, the best way he knew how, to try to help his son fit in, do something that he enjoyed, feel good about something. He talked about the 3 times where Colt rushed him and what he would do. Bear hug him until he calmed down. He told you about the screwdriver incident. The screwdriver incident was where he had bought some tools for Colt to work on his computer. Apparently the screwdriver didn't fit. He was frustrated. He threw it down the hall. I said he wasn't even looking. He didn't even see it. And again, Colt apologized. The state's going to pick out, I'm sure, some messages that don't look great, but you got to look behind what these messages are. Look at the whole colloquy that they are having. And you'll see other messages. Did you make it to school today? I'm proud of you. I love you. You're a good young man. And all the while dealing with 2 other children. He's trying to pull that wagon the best he can. I want to talk just a minute about the investigation. See how I'm doing time-wise. How much time I got left here?
So 2:47 is your cutoff.
I'm working on it. The investigation in this case, the one thing that jumps out is, you'll see the picture of the computer, a computer that's on the floor, and there's a drill there. Now, did anyone tell you what happened to this computer? Were they able to get the chip out of it? Were they able to look into this computer and find out when he was talking on the dark web, who he was talking to, what information they had, how long had he been talking on the dark web? We don't have any of that information. We don't even know whether there was any damage to that computer. We got 60,000 pages of other stuff, but we don't know what all was on Colt's computer. Another thing we don't know, we saw on the video at 8:03, he's texting somebody. It certainly wasn't Colin, it wasn't Marcy, it wasn't Debbie, it wasn't Jenny. So who was it? Was it somebody on the dark web? Was it somebody telling them, hey, watch the news, I'm getting ready to do something? We don't know. Important to know how long Colt had been planning to do something. Another thing that was interesting, you'll see back there, I think it's number 46 maybe, there's a trash can. And in that trash can are the boxes for this ammunition. Where was this trash can? Was a trash can in Colin's room? Was a trash can in the kitchen? Was a trash can in Colt's room? Wouldn't it make sense that he would be loading that gun that morning and throwing it in the trash, because that's what's on top of the trash, you can see it. But we don't know where he loaded the gun. We saw one shell apparently that fell out when he was loading that landed in a mask. Do you know what room that was in? And this photograph of the cutting in April. What in the world is that about? Something to try to make you think he's cutting in April, but they don't put it into evidence, and we don't even know whether it's his arm. You can look at that photograph. There's no scars on that arm. It kind of reminds me of what they used to call lepomania, and that's where a magician says, watch this hand so you won't see what he's doing with this one. They want to bring up everything in the world that they can, all of this stuff, over a 7-year time period, and you're supposed to lump it all together and say, oh my God, he should have known that he was a homicidal maniac. Where's the evidence of that? There's not any. This alleged shrine that they talk about. It's interesting, they didn't even ask Jenny in the statement that they took from her first if she remembers seeing it. Charlie, who came with Debbie, Charlie is Debbie's husband, and Debbie came to pick Marcy up a few days or a week or so before this happened. They didn't see it. Little Coley apparently didn't see it. If anybody saw it, I'm sure they would have brought him in. Debbie didn't see it. Marcy didn't see it. Charlie didn't see it. So why is it so unbelievable that Colin didn't see it? You're going to have some pictures back there. Some of them are from the past. Look at them closely to see whether they match up with what was on the wall when they went over after the shooting at the high school. The gun, everybody's concerned about what this gun looks like. It's an ominous looking weapon. Same kind of weapon that they show on TV all the time. All the police have it. All the soldiers have it. Everybody has these kind of guns. You go to a gun shop, you're going to see a lot of guns like this. It's kind of the Cadillac, the flashy kind of gun. But the reality is it doesn't work any different than a 9mm. So don't let them talk to you about how bad this gun is. It's like any other gun that is a semi-automatic. As I mentioned before, there's only one picture of bullets. Nobody, not Marcy, not Debbie, not Jenny, nobody has said they ever saw ammunition in the courtroom. You know, sometimes it's just as important things you don't hear as things that you do. You didn't have one single message from Colt to anybody that he ever contemplated himself doing a school shooting. Nobody testified that they heard him say that. There's no text messages indicating to Colin that anybody believed that. There's no emails or text messages or telephone calls from any officials telling Colin, you need to be cautious. Your son is a credible threat to people. Nobody ever said that. There's one text I'm sure they'll talk about where he calls us or texts his dad about voices. Another ploy to get out of school, maybe. It was early in the morning, didn't want to go to school. And this is another thing. When they talk about what's foreseeable, what can you foresee? What can you tell? The state's got to show you that he knew that Colt would, not could or not possible, but that he would. That's in their indictment. They have to prove what's in that indictment. Look at the indictment. Look at the things that they have put in there to try to focus. But the word would is pretty important. Have they proven that he would, that he knew that he would? Absolutely not. What's foreseeable and what's unforeseeable? What's unimaginable? Unimaginable that your child will commit murder. Nobody can foresee that. Nobody wants to ever think that. If you or someone you know had a child, grandchild, niece, or nephew who struggled with self-esteem, self-worth, don't make friends easily, trouble keeping up with school, been bullied, who shows signs of anxiety or depression, then you know what it's like to worry about those kids. You worry about whether they'll have friends. You worry about, will they be able to complete school? Will they find something that they're interested in and enjoy? Will they ever be happy? But all the while you think about that as a parent, you love your children and you remain hopeful. And that's what Colin Gray did. He remained hopeful. He took the children on. He didn't send them to DFACS. I'll take care of my children. I'll pull that wagon. And as he told you, I may not have done it correctly. I may have made some mistakes. But he didn't know what was coming, because he didn't have sufficient warning. That's what they got to prove. And what is that sufficient warning? You think if somebody, it's not against the law to have a gun in the house or ammunition. You think everybody that has a gun in their house and their child has anxiety, then that's sufficient warning? Is it really? Is that what we've come to? The state said, you know, we don't want to charge all parents with what their children do. Just this one. What the state said, their little colloquy about someone taking the car, and getting in a wreck, they're not going to charge them. Well, let me tell you, if you have a child that may have a tendency to drink, and you buy that child a flashy car, and you don't lock up your liquor, and he goes out and kills somebody, that's exactly what we're talking about. Do you want this to be the way the law is? This is the first case in Georgia like this. Do you want to make a law? You want to make the law that way? You know, with kids, there's always ups and downs. You always hope to manage their downs. And Colt had some downs. But Colin managed them. He took him to play golf, he took him to do other things, fish, and he took him to hunt, and he took him to target practice. And he never in a million years thought that this son that he loved was going to turn out to be the monster that killed these people. As he told you on the stand when the state was questioning, I never saw that evil before. You saw his reaction when he had to watch that movie. That's the typical reaction of a father who cares and did what he could. It wasn't that he wasn't going to get him therapy. It wasn't that state's going to say, well, you know, he could have done it the day before. He could have done it a week before. They had a plan. And his plan was Lisa Butler, through Jade Baker, is going to talk to Colt, and they're going to suggest to me what we need to do. I've looked at some other places as fallback places. I've emailed people. We're going to let them tell us what does he need to do, and then I'm going to follow through with it. That was the plan. And that was going to happen. But this happened before. Ups and downs, but you got to stay positive. You got to try to keep that trust between you and your child. What never enters your mind as a parent who loves their child and who thinks they understand their child, that they could plan and carry out such a horrific shooting. The state spent a lot of time attacking the decisions of Colin, and at times even mocking his efforts with Colt. Colin was always hopeful in trying to redirect Colt to do things that would help him. Deal with his depression. The state disregards those attempts and tries to demonize Colin, but it's fundamental, natural, innate in parents that they are wired to see the best in their children. We always want to see the best in our children. We always want to try to do the best that we can for our children. He bought Colt a lot of things, thinking that that would make him happy, and it would for a period of time. But you know, there's a lot of days in the last 7 years where nothing but ordinary took place. 7 years is a long time. A lot of days went by where Colt was fine. Don't follow the DAs down this slippery slope of attempting to hold parents criminally responsible for what their children do. Our Constitution is based on we the people. We the people that sit here and we the people that sit over there. And we the people demand that the state prove the case beyond a reasonable doubt. Of the three forms of government, the executive, judicial, and legislating, the judicial is the only one where we the people get to directly make a decision about our fellow human beings. You get to decide. The state doesn't get to decide. We don't get to decide. The state gives you facts. We give you facts. The judge gives you the law. And you make the decision. The state would like for you to think that the system works when you find somebody guilty. But let me tell you, the system works also when you can say to the state, wait a minute, you know, there's some things missing here. I don't understand how this could be. There's conflicts in the evidence. It doesn't fit the law. What's unjustifiable? What's a gross deviation? Gross deviation from normal. The decision is now up to you. Like I told you in the beginning, we appreciate the opportunity to have you as jurors on this case. Everybody's been very attentive, and I think that's certainly important. And I know that you will give Colin every consideration based on what you've heard. And that's all we can ask of any jury. Thank you, ladies and gentlemen. And I'm glad I didn't start coughing. So, thank you.
All right, ladies and gentlemen, we're going to take that short break I mentioned, and we'll come back and go to state's final close. Sit if you want, or can you stand? Disagreement over what goes back.
I think not a ton.
We've addressed, I think, about 90% of what they had issues with in the PowerPoint, which I think was basically red boxes calling attention to certain things. We've removed all those. So I think that was the bulk of it. There might be a few specific slides we have to address.
Okay.
We pulled out the ones we had problems with and gave it back to them. So there are a number of them that are like calendar.
You ready, sir?
All right, bring it in. All right, ladies and gentlemen, state's final closing.
The defense said that Marcy blames everyone else. It's never her fault. Well, ladies and gentlemen, that is the exact description of the defendant. He actually wants you to believe that everyone else is to blame for what happened on September 4th but him. If you remember the lesson that Miss Ryan was teaching on September 4th, you can see the bullet holes to the right, and then there are the dots connected on the left. She was teaching about connecting the dots. And think about these dots related to what the defendant wants you to believe. None of the people that the defendant wants to pin it on had all the information. None of them had all of the dots. He blames good people at the school system who were just doing their job. Lisa Butler knew Colt as an emotionally unstable 14-year-old whose dad would not pick him up during an anxiety attack. When she received the email about Colt asking about school shooter drills, that's the context she had. She did not know that Colt had a rifle in the corner of his room right next to his school shooter shrine. And as a side note, Lisa Butler never testified that her and Colin met about figuring out what to do about Colt's 8th grade year. You remember, Lisa Butler was very clear. The defendant never told her about Colt missing 8th grade. She didn't find that out until Debbie told her. The defense also wants to blame school administrators for not sounding the alarm immediately. D. Martin had never met Colt before. This was his 4th day in classes, 5th day at school. So when she got information that he maybe had a gun in a heavy backpack, no one had actually seen the gun, she didn't have any context. She didn't know that he had gotten an AR rifle for Christmas. She didn't know that he had been investigated for a school shooter threat. She didn't even know about Lisa Butler's phone call with Marcy until after it was too late. And the grossest shifting responsibility is trying to accuse his own daughter, Jenny, of wrongdoing. In the same breath that he wants you to believe he kept the guns in the closet, he also wants you to believe that Jenny is at fault because she looked in his room that morning and didn't see the gun. This is an argument of desperation, but it's not surprising coming from the defendant. Jenny was the one who encouraged the defendant to talk to adults about Colt's mental health. They talked about him actually securing the guns. And the defense says she didn't call the defendant, but she did. She called the defendant at 8:30 that morning. We don't know what was said, but we do know that the defendant immediately identified what poster Colt had around the rifle when he was talking to Investigator Smith. Jenny is not to blame. The defendant is. The only person who knew every single dot, the only person who knew how much access Colt had to firearms and ammunition is that man. And the only person who knew exactly what Colt was capable of is the defendant. He was the one person who could have connected all the dots that pointed exactly at what Colt was going to do. And he was the one person who could have simply taken the rifle away, and he never did. Ladies and gentlemen, we already live in a world where our teachers, our students, our law enforcement officers have to train for the possibility of an active shooter coming to their school. It is preposterous to say that they are the ones to blame for what happened on September 4th. It is insane to say that they are more culpable than the man who armed Colin Gray. The individuals at the school only had minutes to connect the dots. The defendant had years, and he did nothing. And then they want to talk about the computer that was in Colt's room and the person he was texting. Well, the defense knows that hearsay of Colt isn't admissible. They know that we can't prove that the defendant knew what was on Colt's computer, so that's not admissible. It is just an argument to try to distract you from what the actual evidence of what the defendant knew was. And then they want to insinuate that Marcy is really the one to blame. That's not an argument based in law or fact. Did Marcy Gray and her addiction cause more chaos in the lives of the Gray children? Absolutely. And that's why Jenny, by her own choice, doesn't have contact with her mother. But she's not charged because she did not commit actions that constitute a crime. You can see it in the indictment. The defendant is charged because he had custodial responsibility and he gave Colt access to a firearm and ammunition. For the custody part, you can see it on these calendars. The blue shows when Colt was living only with the defendant. The purple are those 2 months and a few days where he was living only with Marcy. And the green in 2024 is the few weeks where they all lived together. Of the last 22 months before September 4th, over 18 of those months, Colt spent solely with the defendant. The defendant had custody. The defendant had the ability to take that gun away. This case is not about who is the worst parent. It's about who armed Colt and who enabled him to commit the crime that he did. And it was that man. And again, listen to the judge about what the law is, because the defense is misstating it again. We do not have to prove that the defendant knew his son was going to commit a school shooting on September 4th. And let me be very clear about this. If Colt Gray had sent the defendant a text message saying, I'm about to go shoot up a school, or if he told him, hey, I'm going to go shoot up Apalachee today, then he would be charged with malice murder because he gave him the firearm and ammunition that let him do it. He would be charged as a party to a crime. And that is a completely different charge. He is not charged with knowing that he was going to commit a school shooting. He is charged with having sufficient warning that Colt would harm someone. If you find that the defendant had sufficient warnings about his son, sufficient warnings that he would hurt someone, that the defendant consciously disregarded that risk by giving him access to ammunition and a rifle, and for the second-degree murder and involuntary manslaughter, if you find that the deaths were reasonably foreseeable, then the defendant is guilty of the crimes charged. Those points are your focus. Not Marcy, not the countless people that the defendant wants to blame, and certainly not the dark web. Those three things are what you talk about in the jury room. Those three things are what you need to find the defendant guilty. So let's honestly seek the truth and talk about all the reasons why you, the jury, know that the defendant is guilty of these crimes charged. First, let's go through the warnings the defendant received that made him aware that his child was a risk to hurt someone. There are three categories of warnings we're going to talk about: Colt's mental health, his violent tendencies, and then red flags. First, the defendant knew that Colt's mental health was deteriorating, and he never got him help. The defense talks about how the defendant was trying his hardest. He did everything he could to get him help. He thinks he should be absolved of guilt because he filled out one form a day and a half after he received it. No. Ladies and gentlemen, opportunity after opportunity went by for the defendant to get Colt help. But he didn't. And he actually actively kept him away from the resources that could help him. And this is consistent with the defendant's whole persona. As Mr. Smith pointed out to him on Friday, every lie he tells makes himself look better. It's not a misstatement, it's intentional. He is a narcissist who has created this facade that he's a good father. And if he puts Colt in counseling, that facade comes crashing down. We can see that as far back as October of 2021, Colt had counseling sessions in Fitzgerald. Remember, DFACS had signed him up with Raymond Dean, and he had 1 or 2 sessions. But when Shonda Goolsby came out for a home visit, the defendant was at his truck packing up. And remember what he told her? He doesn't like defects involved in his family. And he packed his family up and he moved to Jackson County. There were resources available and he took Colt away from them. On May 21st of 2023, that's when Jackson County came out to investigate Colt for threatening to shoot up a school. On June 9th, 3 weeks later, the defendant tells Michaela Anderson, Colt doesn't need counseling. He is angry at his mom. He's being bullied, according to the defendant, and he's suspected of threatening to shoot up a school. He clearly needed counseling. But the defendant lied and said he didn't. Again, not getting the resources he could have. 2 weeks later, in a month after the Discord investigation, they sign a lease in Bexar County and they move. Colt gets on the radar in Jackson County. The defendant takes him off of it. Colt then moves back to Fitzgerald in the summer of 2023. And his grandfather calls the police on him October 3rd. And what happens on October 4th? The defendant comes and gets him and brings him back to Bexar County. Gets on the police's radar. He moves to another county again. And remember, October 4th was one day before he had counseling scheduled again in Fitzgerald. Again, he doesn't get the resources he needs. Then we have October 30th of 2023. Miss Pierre Charles comes out to the residence to do a home visit, and the defendant lies to her and says, we're doing counseling at Bexar Ministry Village. Well, you heard Scott Dakin, their director. They never did counseling there. The defendant even admitted it after hearing from Scott Dakin. They never did counseling there. He must have just made a misstatement. No, he lied, again, to get defects out of his lives and them off their radar. And then one of the clearest derelictions of his duty to his child, he did not put him in 8th grade. He was out of school for an entire year. Remember at Jefferson Middle School? He was on Carol Ann Knight's radar. They had counselors eating lunch with him. They had the school success coach constantly emailing the defendant to try to get in touch with him. And he never responded. That's why they knew his name. Not like he says because he was up there all the time, but because they had to try to get in touch with him so many times. He was on Jefferson's radar. He was getting resources. And the defendant, again, took him out of school, took him off the radar. In the defense, remember what they said? The defendant believed that Marcy had threatened to kill Colt and that Colt knew that. Well, if you believe that, something that traumatic has happened to your child, you get them counseling. You don't keep them out of school for an entire year, isolated, at a time when he believes his mother has threatened to kill him, at a time when his mental health is deteriorating. The defendant isolates him. He leaves him at home. From October to May of 2022, or May 22nd of 2024, every day he leaves him at home. Look at this board. Every time Colt gets on the radar, every time services are available to him, the defendant takes him off and moves him. Let's move to the summer of 2024 and the beginning of 9th grade for Colt. At this point, his mental health is rapidly declining, and the defendant continues to do nothing. On July 20th of 2024, Marcy texted Jenny, Colt had a horrible panic attack last night. And both she and the defendant testified about this. Colt asked him to call 911, was crying, was upset. They didn't. They didn't call 911. They didn't go take him to a doctor. They didn't get him help. The defendant did nothing other than leave the rifle in the room. Fast forward to August 16th. The defendant reached out to a counselor. Finally, maybe he'll get Colt help. Don Crook. And this is how he described Colt to her. He needs help, anger, anxiety, quick to be volatile. I don't know what to do. He admitted his son needed help and that he didn't know what to do. Yet, he did not follow through. He did not actually get Colt help. Instead, he lied again. When Don called him, he didn't pick up. He was just at his house, but he lied and said he was in the field. Instead, he just sent a screenshot of Don's response to Debbie. Why? Because everything he does is for show. He wants to look like a good dad. Hey, Debbie, look, I'm getting Colt help. He wants to appease her so she'll keep giving him money. He doesn't actually want to get Colt help. If he did, he absolutely could have. The defense points out that today still, we don't know what's wrong with Colt. Well, we don't know what's wrong with Colt because the defendant never got him evaluated. If he had, we would know what was wrong with Colt. However, the defendant isn't guilty of these crimes just because he didn't get Colt help. That doesn't make him a criminal. It makes him a bad parent, sure, but not a criminal. The defendant is guilty because he's clearly aware that Colt needs help. These text messages, these researching that he's doing, he knows Colt's mental health is deteriorating. But he still leaves the rifle in the room. That's why he's guilty. We fast forward 10 days. Now we're at August 26th. Colt has another severe anxiety attack at school. Does the defendant pick his kid up, his anxiety-ridden, crying, upset child, and take him to Don Crook's office? Or Advantage, that you heard him testify he knew was open every day? No. He leaves him at school. And then the next day, Colt is absent from school. Colt is home alone the day after an anxiety attack, with the rifle still in his room. The very next day, August 28th, Colt told the defendant that he had no control over what voices told him to do. I have to kind of dance around the inconvenient truth at times. I have no control over what these things say and tell me to do. A day after, or 2 days after a severe anxiety attack, he's talking about voices, and he still leaves the rifle in the room, ladies and gentlemen. 5 days later, on August 31st, the defendant had one more opportunity to just do the right thing. Get your son some help. But once again, he failed his son. He ghosted Marcy, and instead of taking Colt to Advantage on his own, he just went within 2 miles of Advantage. He went to an ATM and got the $400 that he had lied to get Jan to send him out, and then they went to the Guitar Center and bought some stuff. And remember this, the defendant knew Colt was a cutter. He testified to that. He said he knew as far back as when Colt was in Fitzgerald. And you heard Vicki Lee testify. If they had known, if when Colt presented, if he ever presented, and they had known that he was a cutter, they would have hospitalized him. You know what that means? We wouldn't be here today because this tragedy would have been prevented. Ladies and gentlemen, the defendant absolutely knew he could have and should have taken his son to Advantage on August 31st. That very Saturday of August 31st, he texted his sister Jan. I hope everything is going good for you. I need a favor if possible. I'm a couple dollars short on rent and wanted to see if I can borrow some money, and I will Zelle it. Back to you Friday. I'm short because of co-pays for doctors for Colt. I think I'm gonna have to like check him in a place so they can try to help him. He had like a full-on panic attack at school Wednesday. So I'm trying to get him into a psychologist in Athens. He's talking about Advantage. On the Saturday, he is supposed to take him to Advantage. And don't buy his lie that the plan was Project Aware, because he signed the Project Aware form 4 days before this Saturday. He's telling Jan, no, the plan is still Advantage, but he doesn't take him. This text also highlights the absolute reckless disregard the defendant had. What it shows is the defendant's willingness to not only use Colt's deteriorating mental health for his own benefit, but it also his willingness to lie for his own benefit. Remember what investigator Gilliland testified to. The defendant never paid a doctor's copay for Colt. Never took him to a doctor. The defendant even admitted that on the stand, that he lied to his sister. The only doctor he ever paid for was that medicine will, so he could get his own medicine. Weekly, he would go to Medicine Will and get his medicine and pay $90. He was willing to go to a doctor to meet his own needs, but he was never willing to get his son help. And he was never willing to take the rifle out of the room. The next warning the defendant received was Colt becoming more and more violent in the months leading up to September 4th. Colt has documented behavioral issues going all the way back to first grade, where he would kick and hit students at least 2 to 3 times a day. And even if you believe the defendant that he had no idea about that, there's no way that behavior wasn't also going on at home. In 6th grade, another sign of violence is that Colt actually searches how to kill my dad and abuse. He also broke windows and cut a couch in Fitzgerald. And when he moves back to Barrow County with the defendant in October of 2023, he becomes physically aggressive with the defendant. Jenny, in her testimony, detailed fistfights between the two of them and described how Colt would cause holes in the walls of the house. The defendant, even in his interview with Special Agent Ward, acknowledged that things were getting worse, and his text messages show that. Sometime in June of 2024, Colt threw a screwdriver at the defendant. And it wasn't this story that he's made up where Colt got frustrated and just threw the screwdriver across the room. Listen to the text. The defendant texts Colt, okay, question I have is this. Did you tell Mamu that you had a screwdriver in your hand for self-defense? Please tell me the truth, because we both know I wasn't even looking at you when you threw it at me. Again, he's lying to make the situation look better. And one of the biggest warnings the defendant received that Colt was a threat to hurt others, was a threat to use his rifle, was when he got into a physical altercation with Marcy with the rifle. Now, despite the defendant's new version of his story that he told y'all on Friday, this is what he told Investigator Smith.
No, she said, hey, she went down in there and said, you need to get your shit straight, go to school, and we need to just get these guns put up, is what she said.
What do you say?
And that's when they went from bad to worse. And she said she was going out of his bedroom and he pushed her, and she hit the door and the wall and the side of her head. And I'm like, okay, I'm on my way home. So, yeah.
Remember, this is just one day after Colt told the defendant that the blood would be on his hands. That was August 14th. We're at August 15th, and he gets in a fight with Marcy with the gun. And you know the defendant believed Marcy, that Colt was out of control, and that Colt was responsible for this, because he immediately started, as he termed it, researching where to take Colt. He searched for where do I take my son for anxiety on August 15th, after the altercation, and troubled teen options and child psychologists on August 16th. That's also when he reached out to Don Crook. Colt was so angry about the thought of someone taking his gun away that he pushed his mother. There's no legitimate reason why Colt needs the gun in his room. The defendant acts like this is their escape, this is their bond, this is how they get together and hang out. But the reality is they went hunting one time in 2022, and they went to a gun range twice in 2024, with the last time being in March. Colt doesn't need that gun in his room. They're not bonding over it. The defendant testified that the rifle never came into play with Colt's arguments, not until it did with Marcy. He essentially said, but if it had been involved, sure, I would have definitely taken the gun away. Listen to what he is saying. He would have taken the rifle away once Colt used it. Guns kill people. Once Colt uses the gun, it's too late. The defendant does not get absolved of guilt because he would have taken the gun away if Colt had shot someone with it. He doesn't get absolved of guilt because he's hopeful that Colt won't use it. He is guilty of these charges because leaving the rifle in the room caused the death of 4 people. Now the final warning we have is the red flags. And again, we don't have to prove that the defendant had sufficient warning that Colin Gray would specifically become a school shooter. That's not what the law is, just that he would hurt someone. But in addition to the deteriorating mental health, the escalating violence, the defendant did have 3 huge red flags that specifically pointed at Colt becoming a school shooter. Of course, the first one is the fact that law enforcement came out to the defendant's residence in May of 2023. In the context of Colt previously threatening to murder his dad on a computer, law enforcement is coming out to talk to the defendant about another threat of murder on a computer. And regardless when the defendant found out about this, he absolutely knew it before May of 2023. The defendant claims that the Jackson County investigator said that he believed it wasn't Colt. Again, don't listen to his lies. You didn't hear that on body cam, and you certainly didn't hear Investigator Miller testify to that. And you know that that didn't happen because of what the investigator told, what defendant told Investigator Smith. Remember when they were talking about this incident? The defendant said this was a red flag to him and that he took the computers away. If he believed that Colt had nothing to do with this, why take the computers away? And yet, he still bought his son a rifle 6 months later on November 17th. Ladies and gentlemen, the Friday before Jackson County came out to his house was Colt's last day of 7th grade. August 14th of 2024 was his first day of school since that school shooter threat. And this is what he does that morning before school starts. He texts his father, whenever something happens, just know the blood is on your hands. This isn't a text about Marcy. That's another lie he spent 1.5 years coming up with. At no point in this entire text thread where he's talking about the defendant driving off a cliff and how he twists lies does he ever talk about Marcy. This is a threat, and the defendant knew it. This was another dot that the defendant had that when connected, pointed directly at Colt being a danger. And yet, the rifle stayed in the room. Another red flag is Colt's paranoia about his teachers. He texts Marcy on August 28th, "There are people after me and I don't like it, my teachers. I feel as if they're plotting against me. Somehow I feel like they'll hurt me." And we know that the defendant knows about the teachers because as soon as Colt texted Marcy this, she texted the defendant and said, "He just told me about his teachers." The defendant also told Investigator Smith about the teachers and said specifically that Colt thought math teachers were out to get him. And remember Miss Greer's class? She was Colt's math teacher. That was the class that he couldn't get into when he came out of the bathroom. Not only does Colt now have the means to commit a school shooting, but he has a target that he has identified to his dad, math teacher. And then the last huge red flag is obviously the school shooter shrine. Colt wanted his dad to see this shrine. It is on the most prominent wall in that room. It is on the wall right across from the bedroom door. This door is 12.2 feet from that wall. Every time the defendant walked into that room, this is what he saw. Every time the defendant walked out of the bathroom, this is what he saw. And on September 4th, when he walked into the room to see if the rifle was there, this is what he saw. Were you in the back? This is what he saw. You can read the headlines. You can see that these are all the same person. Now, he downplayed how many pictures were on the wall. He said it was just one. But he did finally admit on cross-examination to Mr. Smith that he knew who it was. He knew it was a school shooter on his wall. And it took him a while to admit that because it's really bad evidence against him. But it's also something he specifically tried to cover up. He initially admitted to Special Agent Ward that he knew who the picture was of. He said it was the last school shooter. That's what he told Special Agent Ward. But then he realized he's being investigated. And at that point, he goes into cover-up mode. He told Jenny to specifically lie about knowing about the school shooter shrine. And you know how we know she's telling the truth? Because right after he tells Jenny to lie at the treehouse, he walks from the treehouse to talk to Investigator Smith. And when he talks to Investigator Smith, he lies and says he doesn't know who was on the wall. And that Colt never told him.
Did so he never told you?
He never told me who that was.
Never did?
He never did. He was last.
He lied, and he told Jenny to lie. And one of the most accurate things the defense said when they were direct examining the defendant is that the defendant would have taken the shrine down if he had had time. But he didn't have time. He pulled into his driveway at 12:27 on September 4th. Less than 5 minutes later, law enforcement is already out of their car going to bang on his door. And he heard sirens well before that. He didn't have time to cover anything up. He had time to come up with a lie, and that was it. Don't believe the defendant's downplayed version that there was just one picture on the wall. Colt had pictures of Nicholas Cruz on his wall dating back as far as April 15th of 2024. And the particular version of the shrine that was there on September 4th had been there for months, according to Jenny, 3 to 4 months. And the photos that Colt took of his shrine corroborate that it had been there for a while. When you flip the mirror images, you can see that the photo that was taken on August 9th, August 28th, and September 2nd looks exactly like how the shrine was on September 4th. It had been like that for months. It wasn't just one picture, it was 12 pictures and 4 articles. Teenagers have athletes on their wall. They have movie stars. They have musicians. They don't have mass murderers of children tacked all over their wall. Colt was glorifying a mass murderer for months, a mass murderer of children for months, and the defendant left the rifle in his room. The defendant claims he didn't see this coming. Any reasonable or even unreasonable person would walk into that room, see that, and know exactly what Colt was capable of, and would take the gun out of his room. At the moment a reasonable person saw this shrine, that is the moment they would 100% connect the dots and know that it was Colt who made the school shooter threat. It is when they would connect the dots and know what he meant by the blood is going to be on your hands. And is when they would know who the target was going to be, his math teachers, his school, just like he threatened online and just like his idol, Nick Cruz. The next thing the state has to prove is that the defendant gave Colt access to ammunition and rifles. And, the defense talks about, well, it's not illegal to keep your guns and your rifles unlocked. Sure, there's no specific law in Georgia that says every single person has to put their gun in a gun safe. But there is a law that says you can't not secure your guns if it is a gross deviation from the standard a reasonable person would do. And that's what the defendant did. He gave his son access to a firearm, and that was a gross deviation from what a reasonable person would do. And for the ammunition, we know the defendant was the one who purchased the actual ammunition that was used in the shooting. He purchased it on June 7th. He purchased Lake City Winchester Full Metal Jacket, and that was the ammunition that Colt used and that Colt had left on September 4th. Colt also took pictures of the ammunition he was allowed to have in his room. And when law enforcement got to the defendant's house, more ammunition was just in an unsecured box in the laundry room where Colt often slept. The ammunition was not secured. It wasn't separated from the weapons. It was just out and all over the house. And just like Colt can't buy a firearm, he can't buy ammunition. He's under the age of 18 and he can't get it without the defendant's help. Without the defendant getting him ammunition, this would not have happened. On August 11th, Colt sent the defendant this text message. Could you stop by Academy and pick up a 150 round pack of 5.56? If they don't have it, or if they don't have that, or 5.56, 223 will do. And then he follows up on August 16th, hey, if we can get 150 rounds, that's fine, but could we get at least 50? These texts show more than just that the defendant buys Colt ammunition. It shows another red flag. Another warning that should have triggered the defendant to put the gun up. Why is Colt asking for 150 rounds of ammunition? The defendant claimed on the stand it was to go to a gun range over the holiday weekend. Well, they didn't go to a gun range over the holiday weekend, and there are no text messages showing that they were planning that or that was ever something that they were going to do. But also remember when they went to the gun range on March 29th, the defendant did buy ammunition on March 28th, right before. He went to Academy Sports and bought Hornady Custom 223 rounds. He bought 20 rounds to go to the gun range, not 150 rounds. And he did it without Colt asking him for it. Colt only started asking him for specific rounds of ammunition when he was building his plan to commit a mass shooting. Colt did not need 150 rounds to go to a shooting range. Any reasonable person would have connected the dots and realized Colt wanted ammunition for an entirely different and evil reason. We've also proven he had access to the rifle. First, the rifle definitely wasn't in the defendant's closet like he claimed on the stand. This was another lie to make himself look better. Initially, he actually admitted to Special Agent Maddox and Ward exactly where Colt's gun was supposed to be on September 4th.
I said, hell, it's not him. I said, all the guns are accounted for. They're in my closet. And I said, except for the one Colt put that laser in. I said, I'll call you in a minute. So as soon as I got here, I opened that door, Fox News, I left the TV on, and sure enough, there's Apalachee High, and I'm like, Jesus Christ. I go down to his bedroom, and I just stuck my head inside there, and there's his 2 guitars, and it's laying over there in the corner, and it's not there.
The rifle was supposed to be in the corner of his bedroom, and it wasn't. Not in the closet, like he said on Friday. But that makes him more guilty of a crime. So he claimed on direct examination on Friday that he kept the rifle in the closet. He said, I quote, I moved everything out of the way. Like he was, I think he made hand motions at some point on cross, so he's moving everything out of the way to go check for the rifle in his closet. But during cross-examination, when confronted with the picture of the closet, which clearly does not have everything thrown out of the way, he was like, oh no, I just pulled the blankets apart, and then they fell back down. Ladies and gentlemen, the thing is, just keeping the rifle in the closet isn't much better. Colt still had access to it. It wasn't secured. But he doesn't have a gun safe, so it's the only lie he's got. So he tries to make himself look better by saying it was in the closet. Don't let the defendant pull you into his fantasy world. You know Colt kept the rifle in his room based on all the photos Colt took of the rifle in his room, based on the defendant's own admissions on September 4th, and based on text messages that Colt actually sent the defendant. On August 15th, when they're talking about this altercation with Marcy, Colt says, tried to grab my gun. He didn't say your gun, Dad. He said, my gun. And then he says, I don't know, she backed me into my room and started talking about, are you going to get your gun? Even though I wasn't. And then she grabbed it. My room. Marcy grabbed the gun when she was in Colt's room. He's telling his dad, the defendant, my gun is in my room. The defendant knows where it is. That's where it stays. That's where it's always stayed. The defendant wants you to believe that he didn't need a safe because he and Colt had a trust pact, like a blood oath, and Colt would never use the firearm improperly. But he didn't believe that. If he had believed that, he wouldn't be looking for gun safes. And if he had believed that, he wouldn't have told Marcy that he was going to put up the guns.
It's been like that, like our guns have always been.
But what did Marcy ask you about the guns? What did she say to you about guns?
She just said after the confrontation she had with Colt was like, you need to put them up or get rid of them. And I said, okay.
The defendant wants you to absolve him of guilt because he was about to get a gun safe. He just needed $78 more. Don't believe the defendant's lie. In the month of August, he brought in almost $9,000. He got 5 paychecks for $1,429. He got Zelle after Zelle from Jan and Deborah, and that totaled $8,882. He certainly could have found $78 to buy a gun safe, but the truth was, it wasn't his priority. His priority was getting accessories for Colt's gun. It was getting the sight, the iron sights, the rails. It was getting a school shooter vest that looked exactly like the one Nick Cruz had in his photo. It was getting a half mask that looks like the one he has in that photo. And the truth is, if securing the gun had ever been a priority for the defendant, he could have just used a gun lock that came with the guns he bought. You saw Sarah Van Holm put this in the rifle. It took 10 seconds. 10 seconds would have prevented all of this. But he didn't bother. Finally, for the second-degree murder and involuntary manslaughter charges, the state must prove that the defendant was the proximate cause of the deaths of Mason, Christian, Coach Aspinwall, and Miss Earmy, that their deaths were reasonably foreseeable. And again, the defense is misstating the law. We don't have to prove that the defendant could foresee exactly the way Colt was going to murder people, that he was going to get on a bus with a long gun. We just have to prove that the deaths were reasonably foreseeable. And the board over there, that's enough. You see that, you know what he's going to do. But there's more. The defendant knew that Colt had committed a mass shooting even before the news broke that there was a mass shooting at Apalachee High School. At 10:55, Jenny texted him, "I'm scared." The only time he had talked to her was at 8:30 after she had gotten off the bus. Yet, he doesn't say, "Why are you scared? Everything okay? What's going on?" He says, "It's going to be okay." Because he knew exactly what she was scared of. After he heard that there was a shooting, but before Colt's name was released, the defendant knew for sure his son had committed this crime. Everyone who had a child at Apalachee High School was leaving work and going to the school because they had heard about the shooting. Remember Jackie Garcia? She ran across the street after telling her employer, "I'm going to go check on my daughter." We didn't just have her testify for emotional effect. Her testimony had a purpose. The body cam we played through her had a purpose. It showed that her and parent after parent came running to Apalachee High School. They were terrified. They were wondering if their child was hurt. But not the defendant. He told Special Agent Ward that he left the job site as soon as Colt texted him, "No, I love you and Coley and Jenny." But that text was at 10:03. He didn't leave the job site until 11:18, an hour and 15 minutes later. He knew what Colt was about to do, and he just continued to work. He didn't call George Clackham until 11:07 to tell him he was leaving. He lied to George and said his son broke his arm. And do you remember his explanation on the stand? He needed to tell George something that was serious to get his attention. Are you serious? Are you joking me? Jenny texted the defendant at 11:01. 3 people are dead at the high school. You can see under red, the defendant read that at 11:01. So at 11:07, when he's calling George Clackham, he knows 3 people are dead at the high school. Something serious would be, "Hey George, there's a shooting at my son's high school. I've got to go." He lied to George for one reason. He knew his son was the shooter. He did not need to hide the fact that his child was at a school where a shooting had occurred. He needed to hide the fact that his son was a school shooter. So he lied. Instead of going to pick up Jenny, who was begging for him to come get her, who was scared, he goes to QT and gets a drink, and then he goes home to confirm what he already knew, that his child had murdered people. And even more chilling, even more evidence that he knew what Colt had done, is that as soon as Jenny told him that 3 people are dead, at 11:01, she told him that. And you know what he never did again? Until police got there and he knew Colt was alive? He never texted or called Colt again. After 11:01, his last text to him was at 10:50. Hey, can you give me a quick call? You saw the texts and calls he was doing after he said, I'm sorry. It was constant. But never again after 11:01. Do you know why? He thought his son was dead or in custody. He knew he couldn't answer the phone. Not only was the shooting foreseeable, but the defendant knew he was responsible. You heard how Marcy researched Ethan Crumbly, a case where the parents of the school shooter were charged for not securing a gun. And you heard how Marcy clearly communicated that to the defendant based on their constant phone calls. You heard how the defendant lied to his boss to hide the fact that his son was a school shooter. And you heard how he made Jenny lie for him. The defendant not only knew what his son had done, but he knew what he had done too. Of the 2,000 students at Apalachee High School, only one set of parents suspected that their child was a school shooter. And only one parent had custody of that child and had given him the rifle and ammunition that he used. And that one parent was the defendant, Colin Gray. That is foreseeability, that is murder in the second degree, and that is involuntary manslaughter. Ladies and gentlemen, the defendant wants you to believe that this wasn't his fault, that he was trying his hardest, that being a single dad is hard. The defendant wants you to believe that he needed just one more day, and he would have taken that rifle away and everything would have been different.
I knew I needed just one more day. I think this would have just changed everything because I could feel it. I could see.
You can feel what?
Just his whole attitude change.
How?
The defendant had 292 days between the day he bought his son a rifle on November 17th of 2023 and the day this unspeakable crime happened. 292 days to take any number of heartbreakingly small steps to prevent this mass shooting. He could have not lied to Miss Pierre Charles the day she did a home visit and asked her to get him some help for his child. He could have not bought his son, who had been accused of threatening to shoot up a school, an AR-style rifle on November 17th of 2023. He could have put his son in 8th grade any day that school year so he had resources available to him. He could have called 911 the day his son had an anxiety attack and begged him for help. He could have locked the rifle in his truck the day Colt asked the defendant for 150 rounds. He could have sold the rifle back to Mike's gun room the day Colt told the defendant that the blood would be on his hands when something happened. He could have bought a safe and secured the rifle the day Colt used it in a fight with Marcy. He could have put one of those gun locks he had on Colt's rifle the day he saw the mass murder of children tacked on his wall. He could have answered the phone the day Don Crook called. He could have picked Colt up and taken him to any counselor the day that he had an anxiety attack at school. He could have taken Colt to Advantage Behavioral Crisis Stabilization Unit the day of August 31st. The defendant did not take any of these heartbreakingly small steps. And because he didn't, because the defendant consciously disregarded the very apparent and obvious risk that his son was going to harm people, Mason, Christian, Coach Aspinwall, and Ms. Earmy do not get another day. They do not get one more day. Because of the defendant, their families will never get one more day with them. Because of the defendant, every student and teacher in Ms. Ryan's class will not have one more day where they are not the victims of a mass shooting. One more day where they don't have to fear something like this happening again. Ladies and gentlemen, do not give the defendant one more day to peddle his made-up excuses for why he did nothing to stop this tragedy. Do not give the defendant one more minute of listening to his lies about how he did everything he could. Do not give him one more second of not being held responsible for what happened on September 4th. Ladies and gentlemen, we have done our job. It's time for you to do your job and find him guilty of all charges.
Counsel, are we good to proceed with the charges?
Yes, Judge.
Yes, Judge.
So, ladies and gentlemen, you've been told a couple of times that I will give you the charge at the end of the trial. What I'm about to do now is give you that charge. It is instructing you on the law. We're considering the case of the state of Georgia versus Colin Gray. The grand jury has indicted the defendants for the following offenses: murder in the second degree. There's 2 counts of that. Cruelty to children in the second degree. There are 20 counts in the indictment. 2 of those counts have been removed from your consideration as those kids did not testify. So you'll see 18 counts. Involuntary manslaughter, there are 2 counts there. And reckless conduct, 5 counts in the indictment. You will have the indictment with you in the jury room during deliberations, and you must read it. You will also be considering the alternative charge of 2 forms of involuntary manslaughter with the second degree murder counts, and a second form of involuntary manslaughter with the 2 involuntary manslaughter counts. All of the charges will be defined for you here in just a minute. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you, beyond a reasonable doubt, that the defendant is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. The members of the jury, it's my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your duty to determine the facts of the case from all of the evidence presented. Then you must apply the law that I'm giving to you in this charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or the questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict the defendant only if the evidence, whether direct, circumstantial, or both, excludes all of the theories of innocence and proves the guilt of the accused beyond a reasonable doubt. You, the jury, must determine the credibility of the witnesses. In deciding this, you must consider all of the facts and circumstances of this case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility. This may include evidence of bias toward a party, shown by specific instances of conduct of the witness in question, and may relate to the witness's bias towards the party. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. Now, sometimes evidence is admitted conditionally, that is, although you've been permitted to hear the evidence, it is only admitted and you may only consider it if you also find certain required but disputed predicate facts which allow you to consider such evidence. If you do not find the conditions necessary in order to allow you to consider the evidence, then you must disregard it completely, even though you've heard that evidence. In that connection, I charge you regarding the statements made by the defendant. A statement that the defendant allegedly made has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that it is freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find, as mentioned above, that the defendant's statement was voluntary, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. When a count in the indictment charges the defendant committed a crime in more than one way, you may convict him if the evidence shows that the crime was committed in any of the ways charged. Now, the law provides that criminal action shall be tried in the county in which the crime is committed. Venue, that is, that the crime is committed in Barrow County, is a jurisdictional fact that must be proven by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offense. Venue must be proved by direct or circumstantial evidence or both. I'm going to define the various charges for you here. For murder in the second degree, the state must prove that the defendant caused the death of another, irrespective of malice, by committing cruelty to children in the second degree. For cruelty to children in the second degree, the state must prove that the defendant caused cruel and excessive physical or mental pain to a child under the age of 18 through criminal negligence by consciously disregarding the substantial and unjustifiable risk that his act would harm and endanger the bodily safety of another. Criminal negligence is an act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the act. Involuntary manslaughter. As I mentioned, there are two forms of this. This first is unlawful act, involuntary manslaughter by an unlawful act. For involuntary manslaughter, the state must prove that the defendant caused the death of another without intending to by committing the offense of reckless conduct, which is defined as follows. For reckless conduct, the state must prove that the defendant endangered the bodily safety of another by consciously disregarding the substantial and unjustifiable risk that the defendant's act would endanger the safety of another person. A conscious disregard must rise to the level of a gross deviation from the standard of care a reasonable person would exercise in a particular situation. Now, this is the second form of involuntary manslaughter, that is a lawful act in an unlawful manner. For involuntary manslaughter, the state must prove that the defendant caused the death of another person without intending to by committing a lawful act in an unlawful manner that was likely to cause death or serious bodily injury. To prove involuntary manslaughter by committing a lawful act in an unlawful manner, the state must prove that the defendant acted with criminal negligence, which I have previously defined for you. Now, for each charge that you're considering, to find the defendant guilty, the state must prove that his criminal conduct was the proximate cause of the injury or death. Proving that a defendant caused the injury or death of another human being requires proof of proximate cause. This showing has two components: cause in fact and legal cause. A defendant's conduct is a cause in fact of an injury or death if the defendant's conduct played a substantial part in bringing about or actually causing the injury or death, typically shown through evidence that the injury or death would not have happened but for the defendant's conduct. And a defendant's conduct is a legal cause of an injury or death if the injury or death was reasonably foreseeable. that is, a probable or natural consequence of the criminal conduct according to ordinary and usual experience, not merely a possible result. There may be an intervening act between the defendant's criminal conduct and the injury or death. However, if the defendant could have anticipated or reasonably foresee the intervening act, you may conclude that the injury or death was reasonably foreseeable and caused by the defendant. An intervening act is reasonably foreseeable if it may have occurred in the ordinary course of events or was set in motion by the defendant. An intervening act may be reasonably foreseeable even if that act was not intended by the defendant. So long as the intervening act was a reasonable foreseeable consequence of the defendant's criminal conduct, you may conclude that the injury or death was a reasonably foreseeable result of this conduct. Now, recordings of interviews have been admitted into evidence. Only portions of the interviews have been played to ensure that the videos comply with the rules of evidence, and we also skip past periods of inactivity on the videos. Only introducing portions of the videos was not a mistake or an oversight by the parties, but was intentional so that the video could be admitted as evidence. You are not to hold or consider the unplayed portions of the videos for or against either party. Now, a verdict form has been prepared for you. You will have the verdict form with you. The verdict form lists all of the counts that you're to consider from the indictment and then the additional charges that have been added as alternative charges. Note on the verdict form that there is no count 9 or count 21. Those are the counts that were removed due to those children not testifying. And you're to consider each one of these charges separately and independently. Now, if after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Barrow County, Georgia, did on or about the 4th day of September 2024, commit the offenses as alleged in the indictment and appearing in the verdict form, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty of that count. If you do not believe the defendant is guilty, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty of that count. Now, if you do not believe beyond a reasonable doubt that the defendant is guilty of the indicted crime, but do find that beyond a reasonable doubt that the defendant is guilty of one of the alternative lesser included crimes, then you would be authorized to find the defendant guilty. In which event the form of your verdict would be, we, the jury, find the defendant guilty of blank. Now, I'm going to go through these here so that you see them. So, count 1 is murder in the second degree on the verdict form. It says, we, the jury, find the defendant blank. Below that is an or as to the lesser included offense of involuntary manslaughter by unlawful act. We, the jury, find the defendant blank. Again, it's guilty or not guilty. Or as to the lesser included offense of involuntary manslaughter by lawful act. We, the jury, find the defendant guilty or not guilty. Whichever charge you think is appropriate, that's the charge that you would enter your verdict as I instructed you on the lesser included. So count 1 has those 2 lesser included. Count 2 is cruelty to children in the second degree. We, the jury, find the defendant blank. All of a sudden I'm missing count 2, page 2. All right. Count 3, murder in the second degree. We, the jury, find the defendant blank. Or as to the lesser included involuntary manslaughter by an unlawful act. We, the jury, find the defendant blank. Or as to the lesser included involuntary manslaughter by lawful act. We, the jury, find the defendant blank. Again, consider each one independently and enter your verdict according with your findings. Count 4, cruelty to children in the second degree. We, the jury, find the defendant blank. Count 5, involuntary manslaughter, unlawful act, we the jury find the defendant blank. Or, as to the lesser included offense of involuntary manslaughter by lawful act, we the jury find the defendant blank. Count 6, reckless conduct, we the jury find the defendant blank. I'm not going to go through all these, but count 7 also has lessers. Involuntary manslaughter by unlawful act, we the jury find the defendant blank. Or, as to the lesser included offense, involuntary manslaughter by a lawful act, we the jury find the defendant blank. Each of the other counts is listed on the indictment, we the jury find the defendant blank. And again, enter not guilty or guilty in accordance with your verdict. Whatever your verdict is, it must be unanimous, that is agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. By no ruling or comment that I've made during the progress of the trial, I intend to express any interest upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room would be to choose one of your members to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you're convinced that it's wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about the case. You're also, of course, not permitted to do any research about the case, including looking up anything about any of the legal concepts or anything that you heard during the course of the trial. These rules apply not only to in-person communication, but also using your cell phones to access the internet. If you have any questions, your foreperson needs to put that question in writing, give it to the bailiff, and the bailiff will give it to me. I've got alternates, but aside from that, are there any issues with the charge?
No, Your Honor. Nothing to state, Your Honor.
All right. So we're going to send out, we're going to have to still go through some of the evidence that is not permitted to go with you, so that'll take a few minutes. We will send out the verdict form and the indictment as I indicated. The lecture foreperson, we'll send that out, and then we'll send the evidence in as we get through what's able to go back with you, okay? Juror 122, raise your hand. Juror 130. Juror 139. Okay. If you three will just stay there for now, if the rest of you will go ahead and retire to the jury room. So you don't, of course, realize there are 15 of you, and you always hear about 12-person verdicts and juries. You guys are the alternates, and it's only based on summons number. So as the jury was selected, they go down the list by summons number. I very well may still need you, okay? And to be honest, I'm kind of shocked that we got through a trial of this length without having to use an alternate. Normally, a case lasts about a week, and probably in 25% of those cases, in just week-long cases, we've had to put an alternate on. And it could be somebody got sick, it could be somebody did something that they're not supposed to do. There's a number of reasons that a juror could be removed. If we didn't have alternates and something happened to a juror, then we'd have to try the case again. You can't move forward with less than 12. So presently, you're going to go to the other jury room, the three of you, if you need snacks or drinks, or whatever, they'll get those for you. Don't discuss the case, and really, and I apologize, I know you sit here for 2 weeks or however long it's been. You may still wind up on the jury, but until that time, I have to keep you in the other jury room. Just don't discuss things, and then I'll just follow up with you as I get more information about whether or not we're going to need you to be seated on the jury. Do you have questions? Okay. If y'all will, put them in jury room 4, and then see what drinks or snacks or anything you want. You can take your notes with you.
Is there a problem with the verdict form, Your Honor? Should we need to-
No, there was not a problem with the verdict form. It was more of me just struggling to,
That's fine, I just want to make sure we didn't.
yeah, no, no problem with the verdict form. All right, so no objections to the charge.
No, Your Honor.
No, Your Honor.
All right, I'm gonna paper clip the verdict form to the counts of the indictment so that that can be kept separately. I know we need to address what goes back. I need to step off. I think I have a case or two on point about what goes back and what doesn't, just for a couple of issues. So I'll grab that. If I need the restroom break, go ahead and take it. So we'll resume in just a minute.
Yes, sir.
So regarding the PowerPoint, I think a lot, basically they went through and flagged any pages that they would object to going back. I'd say well over half, probably 75% of the flagged pages were where we had red boxes around relevant dates, times, names, things like that. Once we saw that, our office went back and took all those red boxes out. So we now have a version that does not have that. So I think that resolves a large percentage of it. Mr. Berry's pointed out one slide where we had an FBI press release that was in reference to a text message that was sent by Marcy to the defendant, but we're fine taking out that press release because the slide was just the text of the press release.
Okay.
So we will take that out. There was one additional highlighted one that we had missed that we'll take out. And then I think the only other two issues in flipping through it is there's one picture that's duplicated a couple times that I can address why we did that and why we think it's appropriate to stay. And then we have the calendar that we use for reference throughout with different things on it that I think is appropriate evidence as it was prepared by the witness and isn't continuing evidence that would go back to the jury.
I've got all the numbers, so once they pull those out, if I can go through them, I've probably got maybe 15, 18, so
Yeah.
shouldn't take us.
Can I see the calendar? Is that?
It's on multiple slides, but I can show you like an example of one. We essentially had a running calendar that was filling out. Judge, our contention would be that that calendar isn't Investigator Gilliland's testimony reduced to a visual aid. That is a calendar that helps orient the jury that Investigator Gilliland prepared. I think it'd be more akin to, and I'm thinking, to reference specific case law. I have this case in front of me, but I know a more recent case about continuing witness is there's one about an anatomical drawing that goes back to the jury. It has writing on it. The writing was fine. The drawing was fine. I think a calendar like this that was prepared as reference would go back with the jury. I think it's more akin to that than, say, an affidavit or a transcript of a deposition or something like that, or a witness statement that would obviously be a continuing witness issue.
Judge, we feel like it is like a witness statement, number one, and it should be demonstrative. There are probably half of these that have marked or calendars with writings on them. So testimony is already come concerning what's on the calendar.
Number 71.
71, did they need a minute?
And yes, and they're discussing it.
Okay.
And they'll let us know.
And Judge, the case I'm citing, I believe it was Davis versus State, which is 371 Georgia Appeals 469. It's a 2024 case.
I'm sorry, give me that side again.
Yeah, it's 371 Georgia Appeals 469. It's a 2024 case. It says, typically the types of documents that have been held subject to the continuing witness rule include affidavits, depositions, written confessions, statements, dying declarations. Importantly, it's inapplicable where the document issue is original documentary evidence or when the document is non-testimonial in nature because it's not a reduction or substitute for the person's oral statements or testimony.
So this would not be original documentary evidence. A text message is.
Sure. But this also would not be a substitute for Investigator Gilliland's testimony as it's referencing a specific date to a specific incident, not memorializing what she testified to as like.
How many calendars are there?
Probably
A
15,
few.
maybe 20.
There's one for each date we talked about in August and September.
4 persons ready.
All right, what I'm gonna do is bring the foreperson in and let's see. What they'd like to do. And you would just put them right there at the beginning of the jury box. Come right. No, in John, yeah, out of you. Y'all can be seated. So you're our four-person.
Yes, I am.
It's 4:30. What, y'all discuss whether or not you want to start tonight or come in the morning.
Yes,
what's the
we
decision?
would like to be handed the case today.
Okay. Let me ask counsel this. So the charge, the pattern charge says don't deliberate until everything's been sent back. I don't really know the basis for that. I've never found where that comes from. Statute, case law, I don't know where it comes from. Do y'all want me to give them that instruction, or are you okay with here's the verdict form, here's the indictment? If y'all want to start deliberating, go ahead while we sit through this.
Are we only arguing right now about the PowerPoint?
I think there's more things to argue about.
There are more. I would say yes to the PowerPoint, no to the other evidence. That makes sense? Yes, go ahead without the PowerPoint until we can get it settled.
Okay.
Because that's it's a summary of other evidence. So the evidence that's in the PowerPoint is in here too. But I'd like to see what this other stuff is before they start deliberating.
All right.
But I don't think there's much to
But I don't think that's much to speak at all.
Okay. We're gonna let you, we've got to get some things together. We're still fighting a little bit about what can and can't go in the jury room with you.
Okay.
But go ahead, hold off deliberating, and as soon as we send some stuff in, then y'all can start deliberating.
Okay, thank you.
Jury.
We'd rather kind of iron everything out than have everything go back at the same time.
I understand. Yeah.
After brief discussion, we are going to concede the calendars so that the jury can get the case quicker. So we've started working on that in our office.
Okay.
Which I believe just leaves,
Let me leave this back. One of
a duplicate photo. There's a photo of Colin Gray. The court can see, and you may recall Ms. Brooks in her closing. Colin Gray pointing the laser at the camera. He texted that photo to the defendant. We have it in the context of the text message when that was, showing that photo in the context of when the text message was. We also have it one other time in the context of the purchase, the Amazon picture from Amazon, as well as the line item purchase. So we think it's relevant in both contexts, and it will be confusing to remove it.
It was presented twice.
Yes, sir.
Well, all right, y'all correct me if I'm wrong. Is there anything other than really the continuing witness that keeps stuff out of the jury room in deliberation?
No,
Yeah.
that's the only thing.
Well, the photo's not continuing witness, so it goes on.
And I will let them, if y'all want to go back through and make sure there wasn't something I missed, but I think between that, the calendars, the red boxes, and anything else we can see that should cover it. And that's the unnoticed means.
And Mr. Hobbs, did you say you had an objection to?
I do.
This is the one without the red
I
box.
can do it whenever. Okay. So Judge, in the extractions of the different cell phones that have been put into evidence, obviously there are text messages and Google searches. We are objecting to those going back to the jury under the continuing witness. I will concede there is case law that they are documentary evidence. However, I do not feel that that law is correct and it needs to be changed. If I were to walk into a library and write a note saying, how do you dispose of a body, and hand it to the librarian, and then subsequently prosecuted, and that note came into evidence and was read by an investigator, there's no doubt that would be continuing witness and would not go out with the jury. The modern day equivalent of that very same scenario is me typing the same search on my phone. However, the Court of Appeals Supreme Court has said that goes out as documentary evidence. We feel that that rule is not correct and should be changed, and we would ask that the cell phone records, specifically in regards to the Google searches
and text messages not go out with the jury under the continuing witness rule.
Now, let me make sure, but you do not have a case that says text messages are prohibited from the continuing, barred by the continuing witness rule.
No, Judge, we feel that case is coming. It hasn't come yet. Yes, sir.
One other thing too, Judge, sending all of those out, there are a lot of those that were never used. So sending out things that were never brought to the attention of the jury is just throwing everything out there and letting them go through whatever number there is that they have. I know they looked at 60,000, and you don't want to be sending 60,000 messages back.
Yeah, what is y'all's position on what?
So we obviously did not print out the entirety of the extraction, but a lot of times in Investigator Gilliland's testimony, she referenced what wasn't present. And so on those days, we put timelines so that we can show, hey, the defendant never called 911 on the day of September 4th. Or here's what the defendant and Marcy talked about on August 29th. So there are timelines in there that weren't necessarily presented, because you can't present the entirety of the timeline when we're talking about the absence of something. But the jury would have to be able to, it was admitted into evidence, and it is admissible and it's relevant, and I think the jury would be able to look through it to determine the absence of evidence. We did go through and get rid of anything that, like, there were some text messages between Marcy and Colt that were originally in there, but that the court excluded. We took those out. But I think anything in there currently is relevant and admissible, and it was evidence that the jury can consider. I don't think evidence has to be published specifically to the jury in order for it to go back with the jury. I looked for case law, and there's nothing that says that.
Here's my concern, and again, I don't know. I only saw what the jury saw. My concern is, and this is why I was kind of phrasing it, the foundation's been laid, it's been authenticated, for, let's say, 60,000, the phone dump, 60,000 pages. You've authenticated the phone dump. But that does not mean that all the parts of the phone dump are still admissible, even though a foundation's been laid. For instance, if there were web searches about pornography, well, that's part of the phone dump. The foundation's been laid, but it's not admissible for various, it's irrelevant. So that's my concern, that we've got, I don't know how many pages of documents that the foundation was laid for, but if a particular message or search or something wasn't presented, then it may not be admissible for a variety of reasons.
And I understand the court's position. Our condition is that we only extracted and put in the notebooks what was relevant and admissible, and that what Investigator Gilliland testified to. But some of what her testimony was the absence of information. And so on those days, those timelines are present. We don't believe there's anything that would be inadmissible in them. The timeline, so a timeline extraction on a phone essentially is something that happens, is the part of the extraction that isn't just text messages. The text messages come in the bubbles, and then the website searches, you have the pictures. A timeline just shows what you're doing with your phone at each second of the day. It's all in one document. So it's like the defendant calls Colt at 10:20.
Are these the timelines that she testified about, or are there other timelines that she didn't testify about?
No, when she testified, and when Investigator McCorkle testified about these coming in, the only days that we put in was information she testified about. So for example, August 29th was a day where a lot happened. And a lot of the information was either the absence of information or what Marcy and the defendant were doing. So that timeline is in there because that day, what happened that day is relevant. But we don't have August 28th, for example. We don't have like August 28th and August 27th and August 26th and August 25th. We don't have those timelines in there because not everything that happened that day was relevant. But if she testified about the absence of information, then that whole day of what the defendant did is in there because it's relevant what he did that day. So like September 4th, what he did that entire day is relevant. So that whole day is in there, but not the whole day of July 31st.
All the things she testified about.
Yeah.
The problem is she's created, this is an investigator created this document. And so I don't understand how it could not be continuing testimony if the investigator created that and then they're putting her creation into evidence saying this is what I created.
Well, tell me it's somewhat like you have voluminous records and someone creates a summary of the voluminous records, that summary is admissible. My real concern, just having, of course, I know there are big notebooks, so this big notebook closest, or the one you got your hand on,
Yeah.
Ms. Brooks, is
This is August for Colin.
There are so many things that we didn't go into. I always thought that you had to, whatever you're going to send out to a jury, it has to be something that you've gone over in court and you determine whether or not it was credible, whether it met the standard to go to the jury. There's so many of those that were never used, never talked about, nobody ever said anything about. I don't feel comfortable in sending something to the jury that nobody's even ruled on. If it's text messages that they pulled out and we talked about, then that's one thing, but just to send a whole ton of messages back there that have, we don't know whether they got any public value, not, other than the state saying, well, we think it fits into the probate value, but I don't know how that many text messages can be probated.
And I think our disconnect is not publishing is not the same as not going over. I said not publishing something is not the same as not going over in testimony. Investigator Gilliland went over multiple things in testimony about what was in the text messages, but like I was saying, a timeline that has what the defendant did on a particular day is going to be like 30 pages. You can't publish to a jury 30 pages to show he didn't call the school this day. But we have that in the notebook to show he didn't call the school that day. And therefore, that timeline is relevant and admissible. If there's a particular text message that they find is inadmissible, we've had these books available for them to go through for a month. If there's something that they specifically don't want to go back with the jury because it is prejudicial, we can look at that. But our intent was to put in the notebooks what was relevant, what was admissible, and what was part of Investigator Gilliland's testimony, though some of it wasn't published because of the impossibility of publishing that in that manner. It just has to be through testimony.
Hand me one of the big notebooks, please.
Most of them are small like this. This is the only big one. And if there, you can kind of see, if there are certain.
sitting here to go through.
In my understanding is that the text message tabs, the picture tabs, the web history tabs, those were all presented. The only information that wouldn't have been presented in its entirety would be the timeline tabs. I think if the court wants us to, we can take out some of those tabs that, I mean, like I said, I think September 4th is relevant because that whole day is relevant, and I think August 29th and August 26th. Because those are the days that actually Gilliland testified to the absence of information. But if you want us to take out some of the other timelines, that's the majority of what, those are the only items that wouldn't have been presented in their entirety.
I mean, I just, so that you understand my concern, there are a lot of text messages in here that I didn't see. So there could be a text message in here that says, obviously this would be relevant, but hey, Colt, are you going to go do the school shooting tomorrow? And I didn't know, nobody knew that was in here.
I believe we would have found it.
I believe we would have too. That was a bad example, but just an instance of something that, take something prejudicial. I'm going to, I tried to murder Marcy, but she got away. It is just buried in the text messages that I don't know that a jury would look at it, but it never got to be, I'll use the word vetted, on whether or not it was relevant, whether or not it was improper character evidence.
Well, if the court, like I was saying, I think September 4th, we essentially went through all of those text messages, so I don't think there would be any prejudice for that whole day.
I agree. Every text message shown is admissible, obviously admissible goes back.
But if you want to take, I do think the 26th was the day where Colt was at the panic attack day. He was at school. And our contention is that the defendant didn't call the school, that they called him. And so I do think we need to keep that day in there. And we have Marcy's timeline from the 29th, which I don't think any of her searches would be prejudicial to the defendant or any of her text messages. So the state would be fine to take out the other timelines other than the 26th and September 4th.
Okay, if you want to,
Yeah. And then if they have a question, they can come and.
Sure.
Can we get me some paperwork?
Judge, well, she's doing that, there's one more thing in the PowerPoint that Mr. Berry put to our attention that we would dispute. There's screenshots of the defendant's location data, I think primarily, but maybe not entirely, on September 4th. The state's contention is that those screenshots, one, aren't subject to the continuing witness rule, but also are showing where the defendant was at different specific points in time. I think Mr. Berry felt that they were duplicative. But similar to the other one, I think they're relevant also.
Do you believe that they're continuing witness?
Continuing witness, and also just 4 or 5 of the firehouse itself. But then they do have timelines. I don't understand what they're saying, but I do think it's continuing witness.
So it's a screenshot, or it's a printout of his location at a particular time?
Correct, like a Google map location, but it's the location they different than phone.
Yeah, I don't think location data from a phone is subject to continuing witness. There's more to it than that. I can look at it or discuss it, but just location data extracted from a phone is
Yeah.
not continuing testimony.
This one? Yeah, for now. I have one more. Maybe bring me two.
Judge, can I vote, please? Yes. As long as you're not bringing me a problem.
Now, the jury foreperson came to the door and said they thought they were gonna be able to start right away. They're not gonna wait any longer, they wanna come back tomorrow. And start deliberations tomorrow. Can you bring her out and let her tell you that?
You know, so they shifted gears. They want to come back tomorrow morning. Do you want me to bring just foreperson in? Do you want me to bring them all in?
We don't mind if you just send a message back. Don't discuss the case, but we'll take you home.
We're also about to give them all the things, so.
Okay.
Yeah, if they know it'll just be a couple more minutes, does that change their mind?
I don't want to, we say a couple of minutes and then it turns into 15. Give me the foreperson, please.
I think we resolved all of ours.
I'm just trying not to look like I'm taking out evidence.
Of course, just for the record, we still object to any of the text messages going out. Based on what we hope the courts will do sometime down the road.
There's one attorney that I'm familiar with often argues what the law should be. Our apologies,
It's okay.
but you don't want to go home, come back in the morning.
Yeah, we were under the impression you guys were ready and we were gonna take it then, but if you still hashing stuff out, we'd rather come back fresh in the morning.
Okay. Tell them 8:30, Brooks, tell them 8:30, again, nobody should be discussing the case or looking up anything, that continues. And then you don't deliberate until all 12 of you are in the jury room.
Understood.
Okay.
Thank you.
And then Brooks, if you'll bring me the 3 alternates.
Yes, sir.
Yes, will we have the evidence in there tomorrow when they get here, or wait till they get here, then bring it in?
All right, did both sides see the written charge?
Yes, sir. Yes, sir.
Does everybody think it's okay?
No objection. You just changed the lesser included part?
Yeah, it's, the couple little things that I had just added, I had already written down, so Danielle changed those. All right, so we're gonna send the charges out then?
Yes, sir.
All right. All right, so then, court exhibit. Packet, you email them, and then this one, final one, you just do. Two. Terry, you can put them in the box if you got them there? Oh, you don't?
Yes, we get.
Okay.
Yes.
So the jury's decided that they're gonna come back in the morning to deliberate, so you will be on the bus and come over with them, okay? Did y'all get in your lunch orders for tomorrow?
Yes.
Okay. So, when you get here in the morning, they'll just put you in deliberation 4, snacks, drinks, whatever you want. Continue to understand, though, you're under the same rules. Don't look up anything about the case, don't get on social media, don't talk to anybody about it. We could still lose jurors for any number of reasons, okay? Anybody have questions? You'll have a good evening, see you in the morning, normal time,
Yes, sir.
meeting 8:30.
Yes, sir.
Yes, sir. She was, okay, so, we're fighting about anything else going out. Text messages are going, photographs are going, mistakes removed, things that were red boxes or whatever on the,
Yeah.
did we ever decided that this was the, PowerPoint, is that right?
Yeah.
Right, so we gotta decide that one.
I think,
Well, we've got PowerPoint. We've already gone through that, so I think.
I think you ruled on, either we've consented or you've ruled on everything in the PowerPoint.
Okay.
We did want to put on the record for the Amazon records, we did redact, there was something that was ordered related to masturbation, we took that off. We redacted that.
We're going to ask about that.
But, so this should be either relevant or non-prejudicial items that were purchased.
All right, so you've seen that, y'all are fine with that, is that right?
I'll double check it,
Okay.
just to be sure.
Obviously, the one that says court, just the white one that says is it. Yeah.
And, Your Honor, for the unredacted version of the PowerPoint, that'll just be for the court's record. I put a U next to it, so it's not anyone U for unredacted, so that it's part of the record, but doesn't go back to the jury.
Thank you. So one is the preliminary packet. And two is this final charge. Which is,
Judge, after looking at State's Exhibit 162, I think they can keep in what's relevant, but there's all kinds of things that are purchased that really is not relevant to the case at all. I know they redacted a few things, but
Is there anything prejudicial?
well,
Because part of their argument was, well, I don't know, I haven't seen their exhibit. Can I see it? Sure.
But yes, Your Honor, part of our argument was that he chose to buy things other than gun safes, and so I think anything that is non-prejudicial that costs money would be relevant.
So I see two that were redacted, or it says redacted in the item. Actually, they're not.
Some of them came to us redacted.
Okay.
And we redacted, I think, one additional one. The other one's just, it was like that when we received it.
Again, if there's a particular entry that you think is prejudicial, we'll point that out, otherwise
we'll make a copy of it, take it home tonight, Judge, and we can do that first thing in the morning.
I would otherwise allow that.
Well, Jerry,
You can make a copy over there.
Anything else?
No, Your Honor.
All right. Let's meet at 8:45, just make sure. All right, we'll be in recess until tomorrow morning. Thank you. You know, we won't know. Tomorrow.
Okay.
Judge Green's taking that up for us.
Good job.
I don't think there's anything.
When's your next one? Next week or? Oh, okay. We'll not be trying anything next week.